Good morning, everyone. We're now on the record and video streaming. I am Commissioner French, joined by Chair Keene and Commissioner Duffy, and I'm now calling this evidentiary hearing to order in docket number 22 CONS 3407 CMSC, captioned in the matter of the application of Nacogdoches Oil and Gas LLC for an operator's license renewal. As John told you, I am Andrew French, and I will be serving as presiding officer for this hearing. I do want to start first with the entries of appearance, and I will start with commission staff.
Thank you, and good morning, commissioners. Kelsey Marsh on behalf of commission staff and the public generally.
Operator, Nacogdoches.
Yes, sir. This is John Schlatter of the Morris Lang Law Firm on behalf of Nacogdoches Oil and Gas LLC.
Thank you. Does staff have any recommendation regarding notice of this hearing?
Yes, notice of this hearing was contained in the presiding officer's September 29th order, setting an evidentiary hearing in this docket for Thursday, November 17th, 2022 at 10:30 a.m. via the Zoom video conferencing platform. The presiding officer's order was properly served on the parties. Further, staff notes that operator and its counsel are in attendance today. Based on these facts, staff recommends the commission find notice is proper and that the commission has the jurisdiction to hear this matter at this time and place.
Any objection to proper notice?
No objection.
Hearing no objection and based on staff's recommendation, I do find that notice is proper and the commission has jurisdiction over this proceeding at this time and place. Let me now move to a few preliminary matters and then we'll discuss the procedure for the hearing. First, a few preliminary matters of my own. As you are aware, we are conducting this over Zoom and sometimes things can go a bit wrong. If any party encounters a technical issue, please just ask to go off the record. We can then resolve the technical issue before going back onto the record. Second, it's very important, and I will ask that witnesses keep their microphones off or muted when they're not scheduled to talk. If everyone would also please mute your cell phones in your offices, any other electronic devices, that would be much appreciated. Third, so the parties are aware, if the commission does need to consult among themselves, we will go off the record and the commission will enter into what's called a Zoom breakout room to discuss whatever we need to consult on. Then we'll return from the breakout room and go back on the record. Fourth, since we're doing this by Zoom, please be especially careful to identify exactly what you're referring to when discussing pre-filed testimony and filings. I believe we all have copies of all the items and pre-filed exhibits on hand. So we should be able to follow along if everyone's careful to follow that rule. Next, let me ask if the parties have any other preliminary matters to take up at this time.
None from staff.
Hearing none.
Well,
Go ahead, Mr. Schlatter.
Thank you. Just one matter. We had submitted some of the pre-filed testimony under confidential seal. I'm not sure that we'll get into any of the specifics on that, but just ask everyone to be mindful of that so we can go into executive session as needed.
Very good. Yes, we will enter an in-camera setting if we need to consider those matters. But I will ask, since the parties probably have the most awareness of when we're getting close to those items, please raise it if we get close to it. All right. If there are no other preliminary matters, let me just briefly touch on the procedure for the hearing. In regard to the procedure, the parties are typically allowed to make brief opening statements. After opening statements, we'll have the examination of witnesses. After the direct examination of each witness, there will be an opportunity for cross-examination, commissioner questions, and redirect. Any further examination, I would mention, though, will be at the discretion of the commission. Following witness examination, parties are typically allowed to make brief closing statements, and we may arrange for the filing of post-hearing briefs if necessary, and then we will conclude the hearing. So with that, I believe we will move to opening statements. It's my understanding the parties haven't agreed on any particular time length, but we have sort of agreed to keep them fairly brief. So let us now begin with commission staff. Mr. Marsh.
Thank you, Commissioner French. May it please the commission. We are before you today based on Nacogdoches' appeal of a commission order denying its application for license renewal. The reason for that denial was based on Nacogdoches' license being suspended for noncompliance with docket 20-CONS-32AA-CMSC. Nacogdoches attempts to distract us from that main point that its license is suspended with various excuses. However, the main thing to focus on is the fact that at this time, Nacogdoches' license remains suspended for noncompliance because it is 14 wells behind in its commission-approved agreement. The question before the commission today is whether Nacogdoches is in compliance with all requirements of Chapter 55 of the Kansas statutes annotated, all commission rules and regulations, and all commission orders and enforcement agreements, which is necessary in order to issue any license renewal. Staff's position is that Nacogdoches fails to demonstrate this type of compliance. Thank you.
Thank you, Mr. Marsh. Mr. Schlatter.
Yes, sir. Commissioners, thank you for your time today. As noted by Mr. Marsh, we're here today on Nacogdoches, and I can't say the word Nacogdoches. I can't spell it. I don't expect the court reporter to spell it, so I'm going to refer to Nacogdoches as NOG or operator from this point forward. But yes, we're here today on NOG's license renewal application. The premise of the hearing is simple, as Mr. Marsh pointed out. Nacogdoches or NOG wants to renew its license to continue progress under the compliance agreement. Ideally, it would like to implement an enhanced oil recovery project on the lease where the wells at issue are situated. This project will prevent waste, it will protect correlative rights, and it will simultaneously bring the dozens of wells subject to this agreement into compliance with commission regulations. Kind of a sweet triple right there. We're going to knock everything out of the park. On the other side, staff wants NOG's license denied, its status as an operator in Kansas revoked, and to what end is entirely unclear. It's just what they want. I believe that position is contrary to the commission's mandate to prevent waste, to protect correlative rights, and to enforce its regulations. As noted, the root cause or underlying issue in denying NOG's license is that it's allegedly non-compliant with the compliance agreement entered in that prior docket, 20-CONS-3407 CMSC. That agreement was entered in June of 2020. I think the evidence here today will show that the sole and only reason NOG's license was denied was because of that alleged non-compliance. Obviously, NOG disputes that. I think the evidence shows that NOG believed at all times that it was achieving those benchmarks that were set in that compliance agreement, and that really the root of the cause is poor communication or a complete failure to communicate on the part of staff. You know, it left NOG confused as to what it was able to do as an operator in the state. At one point in time, it was told it was illegal for it to conduct operations, that it must shut in all of its wells, and that it would face punitive fines in excess of $5,000 if it didn't cure these issues. At the same time, the clock kept running on its compliance. It's a mixed message at best. I think the evidence will also show that NOG was never more than one well behind, at least up until its license was revoked under this compliance agreement, and whether or not it was actually one well behind is in dispute. Now, that being said, NOG is also here because it has a plan to bring this lease into compliance. It has a plan. It proposed this plan to staff on numerous occasions. It's splattered all over the record. The plan wouldn't conform to the 3 wells per quarter, but it would ultimately achieve the objective, and that's to bring all the wells into compliance. It would also allow them to produce oil, preventing waste and protecting correlative rights. It would result in substantial investment in a community that desperately needs one. And all of these things are consistent with what the commission is here to do: prevent waste, protect correlative rights, and also enforce its own regulations. You know, equity is also at play here today. Staff, I think, as Mr. Marsh just noted, believes that 27 wells should be in compliance. Well, that includes wells since March of 2020 when their license was revoked and they were told it was illegal to conduct operations. So the clock somehow kept running even though NOG wasn't allowed to operate in Kansas. I believe this to be a grossly inequitable position. NOG was never told that it could continue to operate. In fact, it was told it could not continue to operate. And I think, if anything, at the very least, NOG's rights or obligations in that agreement should be told during that time period, beginning in early of March, to the president whenever the commission renders its order in this matter, just as a matter of fairness. So with that, there's an order in place. I believe the commission has the full power and authority to amend its order and I'm talking about the compliance agreement, to amend that agreement and to replace it pursuant to NOG's request under its development plan, and doing so would accomplish and be completely compatible with all of the commission's mandates to prevent waste, protect correlative rights, and also to ensure the enforcement of its regulations.
Thank you, Mr. Schlatter. All right, we've concluded opening statements, so I think we are ready to proceed with examination of witnesses, and we will start with staff. Mr. Marsh, you may call your first witness.
Thank you, Commissioner French. Staff calls Nancy Borst.
Ms. Borst, if I can have you raise your right hand. Do you swear or affirm that the testimony you shall give today is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Witness is yours, Mr. Marsh.
Thank you. Can you please state your full name for the record?
Nancy D. Borst.
And Ms. Borst, by whom and in what capacity are you employed?
I'm an administrative specialist for the Kansas Corporation Commission Conservation Division.
And Ms. Borst, what is your work address?
266 North Main, Suite 220 in Wichita.
Are you the same Nancy Borst who caused to be filed in this docket direct testimony consisting of 5 pages on August 26, 2022?
Yes.
Was this testimony created by you or at your direction?
Yes.
Now that you are under oath, do you have any corrections to make to your testimony?
No.
Do you swear the answers contained in your pre-filed testimony at the time it was filed are true to the best of your knowledge?
I do.
At this time, staff moves for the admission of Ms. Nancy Borst's pre-filed testimony of 5 pages filed on August 26, 2022 into the formal record.
Any objection? Hearing none. Hearing none. The reference testimony will be admitted into the record.
Thank you. At this time, staff tenders the witness for cross-examination.
Thank you, Mr. Marsh. Operator, do you have cross-examination for this witness?
Yes, Commissioner French, very briefly. Ms. Borst, thank you for your time today. Got some good news for you. I have very few questions for you, so you'll be done here in a moment. I just wanted to confirm a couple things about your testimony. Reading it, it appears that the sole and only reason NOG's license was denied was because it had been previously suspended for non-compliance with the compliance agreement entered in that docket 20 CONS 3288, I believe it is. Is that correct?
Yes. If I receive a renewal application from a license that's suspended, I cannot process it until it is no longer suspended.
So at the time you received the application, the license was suspended?
Yes.
Okay. Put another way, it's NOG's license would have been renewed, but for this alleged non-compliance, there are no other reasons why.
I have not processed the application, so I can't speak to that.
But you're unaware of any other reasons as to why its license could have been denied?
Not at this time.
Okay. And real quick, and John, Mr. Myers, I'm going to try and drive, and if I fall on my face here, I'll have you help me out. But I want to refer you to, in your testimony, you referenced an Exhibit A to the Commission's order denying application. And I just want to put that up and make sure we're all talking about the same thing. Okay, are you looking at what I'm looking at? An order denying application?
We are not seeing it yet. Sometimes there's a lag.
Okay. Oh, I have to push share. Let's see. How about now?
We do see it now.
Okay,
Order denying application for license.
okay, and the letter as Exhibit A. And I wish I could see it. I can still see everybody just way over here. Exhibit A.
Mr. Schlatter, thank you. I was going to ask you to zoom in. Thank you.
I can't even read it and I'm standing 2 feet from it. Okay, is that better? And Ms. Boris, this is the letter referenced in your testimony, correct?
Correct.
And it's dated March 2nd, 2022. And just for the record, this is Exhibit N18, which has not been offered into evidence yet, but will be shortly. And it says that your license is currently suspended for non-compliance with the commission order in that docket number I just read, 20 CONS 3288. Signed by Kelsey Marsh. Correct?
Correct.
Okay. Ms. Boris, that's all I have for you. And so I would move for the admission of what I've identified as Exhibit N18. The commission's order. The commission can probably take judicial notice of that in any event, but let's go ahead and get it in the record if that's okay.
Any objection from staff?
No objection.
Hearing no objection, it will be admitted. All right, Mr. Schlatter, you're at the conclusion of your cross-examination questions?
That is correct, Commissioner Friends.
All right. At this time, we will turn to see if any of the commissioners have questions of this witness, and I will begin with Chair Keen.
Good morning, Ms. Borst.
Good morning.
A couple of questions from me, just for the record. When was the operator's license suspended? You know the date of that?
I do not.
I believe Mr. Slatter indicated that he thought it was in March of 2020. Do you have access to anything that can tell us that?
Let me look real quickly, Commissioner. Most recent license suspension was July 21st of 2021.
7/21/21.
Yes, sir.
And you have the reason for that suspension there?
Non-compliance with 203288, the compliance agreement.
Okay, so in essence, it was suspended due to the non-compliance with a commission-approved compliance agreement.
Yes, sir.
All right. Ms. Borst, I'm turning to your direct pre-file testimony of August 26, 2022, in particular, pages 4 and 5. Beginning with line 20, the question is, would you summarize your recommendations? And correct me if I'm wrong, but in essence, as I understand it, you're suggesting that the order denying the application for a license be affirmed. And it appears that you're saying that is due to the failure to address underlying issues resulting in the original suspension of the license by the deadline provided in the NOV. Is that correct?
That's correct.
So when you, in order to make that statement, when relying upon facts that would give you reason to believe that there was a failure to address underlying issues, what documentary evidence or records are you relying upon to reach that conclusion? Are those primarily from RBDMS or from other sources or from both?
Well, Commissioner Keen, it really comes down to a pretty simple thing for me. If a license renewal comes in and the license is suspended, that creates a hard stop for me. Nothing gets done until staff tells me the license is unsuspended.
All right, fair enough. So within the records that are before you and available to you, how can you determine that the license is still suspended?
The Kohler system actually shows license operator names in red when they're suspended. So when I received this renewal, Nacogdoches's operator name was in red. I confirmed they were suspended and I immediately put it on hold.
In your experience, and you have rather extensive experience here, how reliable is that Kohler system in identifying suspended licenses in the way you've just indicated?
Extremely.
All right. Let me go back to my first question, and this will be my last. That had to do with when the license was suspended. I think your answer to me, I'm paraphrasing here roughly, was that most recently it was suspended on July 21st, 2021. Is that correct?
That's what our records indicate, yes.
Was it suspended prior to that time?
Have to look here, hold on.
Thank you.
The license was suspended in 2015 on a different docket. And that appears to be the only other suspension that I'm seeing.
And by your records there, can you tell me fairly easily, when was the operator first licensed?
First licensed February of 1997.
Thank you very much. That concludes my questions.
Thank you, Chair Keen. Commissioner Duffy, do you have any questions?
Good morning, everyone. No, I have no questions for this witness. Thank you.
I also have no questions. Mr. Marsh, do you have any redirect?
I do not.
Okay. Ms. Borst, I believe you may step down at this time.
Thank you.
And Mr. Marsh, you may call your next witness.
Thank you. Staff would call Ryan Dooling.
Mr. Dooling, can I have you raise your right hand, please? Mr. Dooling, do you swear or affirm that the testimony you shall give today is the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
All right, thank you, Mr. Marsh. The witness is yours.
Thank you. Can you please state your full name for the record?
Ryan M. Dooling.
Mr. Dooling, by whom and in what capacity are you employed?
I'm employed by the Kansas Corporation Commission as the compliance officer of District 3.
And what is your work address?
I'm sorry.
What is your work address?
My work address is 137 East 21st Street, Chanute, Kansas.
And are you the same Ryan Dooling who caused to be filed in this docket direct testimony consisting of 9 pages and 4 exhibits on August 26, 2022, and rebuttal testimony consisting of 8 pages and 1 exhibit on September 23rd, 2022?
Yes, sir.
Was this testimony created by you or at your direction?
Yes, sir.
Now that you are under oath, do you have any corrections to make to your testimony?
I do not believe so.
Do you swear the answers contained in your pre-filed testimony were and are true to the best of your knowledge?
Yes, sir.
At this time, staff moves for the admission of Mr. Ryan Dooling's pre-filed testimony consisting of 9 pages and 4 exhibits filed on August 26th, 2022, and 8 pages and 1 exhibit filed on September 23rd, 2022 into the formal record.
Is there any objection to admission of the referenced testimonies and exhibits into the record?
No objection.
Hearing none, they will be admitted.
Thank you. At this time, staff tenders the witness for cross-examination.
Thank you, Mr. Marsh. Mr. Schlatter, any cross-examination?
Yes, Commissioner Prince, I do have some cross-examination for Mr. Dooling. May I?
Yes, go ahead.
Thank you. Mr. Dooling, again, thank you for being here today. I can't promise you I'll be as brief as I was with Ms. Boris, but we'll get through this. I'll also promise to do the best I can to share a screen until I cannot take it anymore, and then we will have Mr. Myers help me with that. So, first question, Ms. Boris just testified that she's unaware of any other reason why NOG's license renewal application was denied other than alleged non-compliance with the compliance agreement. Is that your understanding as well?
Yes, sir.
And are you familiar with this compliance agreement?
Yes, I am.
Okay, I'm gonna go ahead and publish that. This is Exhibit N2, which is attached to Mr. Ivy's testimony, which isn't admitted, but should be forthright. So here it is. Can you see that?
I do not see it yet.
Okay. Oh, you know what? It's this share button that gets me every time. It asks me if I want to share it, and I say, yeah, and then it asks me again. Okay, how's that look?
I can see it.
All right. So the underlying premise of this agreement is that NOG had about 60 wells out of compliance with KR 823111, which are the commission's temporary abandonment regulations, and needed some time to bring those back into compliance. Is that a fair statement?
Yes, sir.
There are effectively three ways to do that. You can plug them, you can return them to production, or you can obtain TA status for them, correct?
Yes, sir.
Okay. When did you become responsible for administering this compliance agreement on behalf of District 3?
I was hired as a compliance officer in September of 2021. However, I did not really begin looking at the compliance agreements until probably March of 2022 due to other docketed matters that was extensively being worked on to go in front of the commission.
So I'm sorry, what was that date? June of 2022?
No, sir, I was hired, or when I was hired as a compliance officer, become working with the compliance agreements.
When you started administering this specific compliance agreement?
I started working basically in March of 2022, working on the compliance agreements.
Okay. And previously, John Almond, or was it Alan Dunning, was responsible for it?
That would have been John Allman.
Okay, I'm going to refer you to an exhibit marked as N8 from John Almond. It's an email from John Almond dated November 9, 2021 to Mr. Ivy. Looks like you're CC'd on it. It basically says that Mr. Almond is retiring at the bottom effective December 31, 2021, and that Mr. Dooling will take over from there. So that's sort of the passing of the baton, if you will, from Mr. Almond to yourself, correct?
Yes, sir.
Okay. So back to N2, and I'm going to go ahead and address some of the questions that Mr. Keen had asked when he was talking to Ms. Borst. This agreement was entered into by NOG May 28, 2020, commission staff June 1. So I believe the commission adopted it about 10 days later. So that's when the compliance agreement began, correct?
That's when everybody signed. I'm not be able to confirm when it was actually ordered by the commission without having to go look that up, but I'm assuming that you probably have, and that is correct.
Okay, I believe it was June 11th, but it's not, it doesn't matter. It was soon thereafter. So let's go down to paragraph 5 of the compliance agreement, which again is exhibit N2. And it says, except as provided by and under this agreement, staff will not pursue operator for any violation of 82.3.111 for the subject wells that occurred prior to June 30, 2025, except for wells brought into compliance after commission approval of this agreement that subsequently fall out of compliance. Does this effectively mean that once a well that's part of this compliance agreement is brought into compliance, that it won't it no longer becomes part of the agreement, and if it later falls out of compliance, a separate enforcement action needs to be brought?
That is correct.
Okay, so, and we can scroll down to one of the wells just by way of example. So let's go here, Spradling, CH Spradling 51. If NOG brought this well into compliance by plugging it, producing it, or temporarily abandoning it, staff signed off on that, that well, for purposes of this agreement, is gone, correct?
That well, what that means is they complied with that well and got it back into compliance. Yes, as of the date noted. If
Okay,
that then falls out of compliance, it cannot be added back to the compliance agreement. That is
okay.
correct.
Thank you. That was much better, much more well said than the way I described it. And so if that well did fall out of compliance, say it was producing, then it became inactive for more than 90 days, then there would be a new enforcement action brought by District 3, correct?
Correct.
Okay. Let's go to paragraph 3 here at the bottom. And this says and I'm going to focus you on this language here. If operator remains out of compliance with this agreement for any reason, staff shall immediately send a notice of non-compliance and license suspension to operator. So does that mean that if staff thinks that operator is non-compliant, that it will send it this notice, this, I believe it's referred to as a notice of non-compliance and license suspension? That's staff's way of communicating that the agreement, that it believes that operator is not compliant with the agreement.
Yes, sir.
Okay, and then it goes on to say, operator's license shall remain suspended until well plugging or repair is resumed in accordance with the compliance schedule contained in the status update. I'm not sure what that means, but what the status update document is, but I'm reading this to mean once the operator gets back into compliance, its license should no longer be suspended, or it should be reinstated, to use a different word. Is that correct?
That is correct.
Okay. Okay, I think I can get rid of this particular exhibit for now. And you're just gonna have to, those are my daughters, if it's still sharing. You
It's
testified.
very fine.
Yeah, I think we'd all be better if we just did that all day. You testified in your pre-filed testimony that as of August 26th, 2022, operator had only brought 13 wells into compliance, correct?
That is correct, but could you take me to that, please? Where was that?
Yes, sir. I'm gonna get to that. Well, it wants to do this to me now. Okay, so I believe it is at,
Now, is this in my
this is your,
testimony or in the rebuttal?
it says rebuttal, and that's not even what I want. I want your direct testimony. Okay, I'm gonna go to page 6, line 4. Okay, it says, the question is, how many wells has operator returned to compliance to date? Staff records indicate operator has brought 13 wells into compliance with the terms of the agreement. The reference to the agreement, I believe, is a reference to the compliance agreement.
That is correct.
Okay, and it goes on to say this is less than the 24 wells that would have been required by the end of second quarter 2022. So June 30, had the agreement continued to run, 24 wells was the obligation.
That is correct.
Okay. But I believe there is an email from you earlier that indicated that 17 wells had been in compliance. And I'm going to pull that email up too. This is the exhibit marked as, I didn't write it down. Bear with me just a second, sir. I think it's N10. Yes. So we go to exhibit N10. It's in Mr. Ivy's pre-filed testimony. Okay, so exhibit N10 is an email from yourself to Mr. Ivy concerning the docket in which the compliance agreement was entered into. And if you go down here, it says, our records indicate you are one well short of fulfilling your objective for fourth quarter ending 12/31/2021. So the end of 2021. At that time, I believe NOG's obligation was 18 wells. Is that correct?
I believe that is correct. Yes.
Okay, so here you're saying you're one well short of 18, correct? So that would mean, and check my math on this, 17 wells were in compliance.
Yes, sir. That is a reminder letter that we try to send out to every operator that is in a compliance agreement halfway between the quarter. This email was sent, I believe it, I don't know where it went on the screen, but I believe it was March the 2nd. And at this time, I had not reviewed any of the wells that was brought back into compliance. I was just going off of what had already been put into the database. And at that time, it showed 17 wells were put back into compliance. That is why that email says that they need to bring 4 wells into compliance by the end of that quarter to fulfill the quarterly objectives.
Sure. So it's possible Mr. Dunning had found that 17 wells were in compliance and you were just coming forward from his work.
I was coming forward from his work, but I believe if you would like for me to go further, I can pinpoint the 2 wells. The reason there were 17 was the operator had filed CP1 plugging applications to plug wells, I believe, for the third quarter of 2021. And after reviewing, I first found there was no CP4s filed, which is the operator's plug-in reports. And also the staff CP23s hadn't been filed. So after investigations, I contacted the plugging contractor and verified that EOS-1 and EOS-I-1 had not been plugged.
Okay.
And those two wells had been previously counted towards meeting of objective beforehand and should never been enlisted on being in compliance.
Yeah, Mr. Dooling, if it's okay, I'll get you there later on.
I apologize.
No, that's no problem. I did not want to interrupt you, but we'll get into that later. I just want to talk about what staff, which, Mr. Dooling is staff, Mr. Dunning is staff, had communicated to operators. So operator can only know what staff tells it. It doesn't know what staff is thinking or what it's doing in an investigative standpoint. And so on March 2nd,
go ahead.
No, on March 2nd, NOG reading this email would believe that staff thought it had brought 17 wells into compliance, correct?
I will agree with that. Correct.
Okay. And we talked earlier, once a well's in compliance, it's not supposed to go back on the compliance agreement. A separate enforcement action is supposed to be brought, correct?
That is correct.
Okay. Okay, let me take another stab at pulling up some exhibits here. This one is marked as exhibit 19, or that's how I've marked it. I would ask that it be marked as that. And this is staff's response to my discovery request that I issued in this docket. And so As you can see, my questions, I believe, are in black, and staff's response to my questions are in red. This is dated July 25th, 2022. It's on commission letterhead. And this is a response to our information and document requests dated July 13, 2022. And I'd like to direct your attention to information request response number 3, which I'm going to try and fit on here. It says, describe which of the subject wells have been brought into compliance. And we can count them 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 wells. These are the 13 wells referred to in your testimony.
That is correct.
Okay, I'm gonna now scroll to the bottom here. These are my document requests. So these are NOG's requests for documents from staff in discovery. Number 7 says, provide all quarterly compliance reports you prepared in connection with this docket. And it referenced document request number 7. And so I'm going to go to document request number 7. And I'm going to get it straight so we can read it without turning our neck sideways. And these are the quarterly reports that I believe staff prepares indicating NOG's compliance with the compliance agreement. Is that correct?
That is correct.
Okay, and so this 9/30/2020, so the agreement was entered into in June of 2020. So first quarter thereafter, or third quarter of 2022, it was to bring 3 wells into compliance. And according to this report, it had done so, correct?
As of the third quarter 2020, yes, sir.
And 12/31/2022, fourth quarter of 2020, objective 6 wells, wells brought into compliant 6, correct?
Yes, sir.
So far, so good. First quarter of 2021, 9 objective, 9 brought into compliance. Looks like NOG is doing what it's supposed to do. And now we get to June, so second quarter of 2021, and it's saying there's 11 wells in compliance. Correct?
That is what it says. Yes, sir.
So 1 well short according to staff. And if I'm just going to assume that it's this ORD 26B, which was brought into compliance according to this report, July 6, and the Spradling, CH Spradling 51, which were the 2 wells in addition to the 9 from the previous quarter brought into compliance. Is that a fair statement, or do we need to scroll back and forth?
No, sir, that is correct.
Okay. And so we fast forward to third quarter of 2021, and the objective is 15, and NOG has 15 in compliance. So 1 short at the end of the second quarter of 2021, September of 2021, back into compliance, correct?
That is what that report says.
Okay, and this is a report that staff prepares.
That is correct.
Okay. The next report we have is dated March 31 of 2022. I don't believe that a report was ever prepared for the fourth quarter of 2021. And it wasn't furnished in discovery. Is it your understanding that there's no such report?
That is my understanding. Yes, sir. I did not see where John had ran the end of this, the fourth quarter of 2021. I did not find a report.
And John is who?
John Allman, he is the past compliance officer before me. He retired.
Okay. So he was, and he works in District 3.
He did, yes.
Okay, and he would have been working with Alan Dunning, who was your predecessor. Is that correct?
My predecessor, no. I mean, he would have been working with Alan Dunning. He was in that, for that area. He was the ECRS for that area.
Okay. Alan Dunning was the compliance officer before you, right?
No, sir.
Oh,
John Allman was the compliance officer before me.
Okay, thank you. Okay, anyways, back to this report. Now we're showing 13, and I assume these are the same 13 wells that were in the information request responses. Is that correct?
That is correct.
Okay. So let's look at a new exhibit, and this, I think, will kind of dovetail off one of the questions that Chair Keen asked Ms. Borse earlier. And so this is a letter. This is marked as Exhibit N1. This is a letter dated July 21, 2021, and it's from Commission staff, and it's called Notice of License Suspension. It says, your license is suspended. That was the date that Ms. Borse indicated was the date that NOG's license was suspended when she was testifying. It says, if commission staff discovers you performing oil and gas operators, staff will recommend a shut-in order, including additional $5,000 penalty. It is illegal for you to conduct oil and gas operations in Kansas. Is this the letter that was issued in response to NOG only having 11 of 12 wells in compliance according to staff's report at the end of second quarter 22?
I assume that is the letter, yes.
Okay. And so this would be, there was reference to a notice in the compliance agreement that if operator falls out of compliance, staff will immediately notify it. This is that letter. Is that?
Yes, sir.
Okay. My question is, we went through that report for third quarter of 2021, and it said that NOG had brought 15 out of 15 wells into compliance. Why wasn't its license reinstated at that time?
I do not have an answer for that. If I know how now as a compliance officer, if this would happen and we confirm that all the wells have been brought back into compliance that meets their objectives, either passed, then I will notify legal staff, notifying them that the operator has fulfilled their past due agreement and license should be reinstated.
And so NOG has received this letter that its license suspended, that it says it's illegal to conduct operations, and that if it does, it's going to get fined $5,000. But it was never, its license was never reinstated.
That's correct. That's the way I understand. Yes, it's been suspended since July 21st of 2021.
And that's notwithstanding that the compliance agreement required its license to be reinstated upon it returning to compliance, correct?
Would you repeat that, please?
Why don't I just let the compliance agreement speak for itself here? So I'm back at Exhibit N2, and it says the operator's license, paragraph 3 on page 2, very top of the page. Operator's license shall remain suspended until well plugging repair is resumed in accordance with the compliance schedule.
That is what that says. Yes, sir.
So the agreement that NOG was operating under mandated its license being reinstated, but its license was not reinstated.
It does not appear to be. That is correct.
I'm going to call up another exhibit here. This is Exhibit N9. It's working a lot better if I don't close them. Exhibit 9 is an email. N9 is an email from Mr. Ivy to Mr. Russell and you, sir, Mr. Dooling, regarding its 2021 quarter 4 compliance and development plan. Like maybe would you like to take a minute to kind of read through this real quick? Just
Sure.
let me know when I need to scroll down.
Excuse me, Mr. Schlatter, could you scroll back up and so I can accurately note the date on that? Thank you. I appreciate that.
And sir, I've made it down to where the ORD 18B, that's where I've made it to.
I think it trips over one page, so just let me know when you're ready for that.
I've finished. I've completed it.
Okay, so scrolling back up here, there's a comment here about what Alan Dunning had told Mr. Ivy about how earlier this year, we discovered 3 well plugging records of wells that are on our compliance agreement that Alan Dunning told me we could get credit for and save for a rainy day if we weren't able to get to wells in time. Since we couldn't get to the wells in time, we're going to cash these in and get credit for them. And this is the ORD 18B, the ORD 23B, and the Spradling 48. So Mr. Ivy is telling you that he's tendering these plugging records to get credit for what I believe would be wells 16, 17, and 18 under their compliance agreement, correct?
That's what he's entailing, yes.
Okay, and if NOG got credit for these wells, as he indicated he thought he could, it would have been in compliance, or NOG would have been in compliance with its compliance agreement as of the fourth quarter of 2021.
I believe that is correct.
And we don't have a report from fourth quarter of 21 for whatever reason, but this is what NOG is saying on December 31, 2021. And this is what it believes. Correct?
That's the way I read it, correct.
Okay. Now, I have no record of either you or Mr. Russell ever replying to this email. Did you?
I did not personally. I noted with Troy, at that time, I was still actively involved with other dockets, one major docket. And I did not respond. He said that we would respond to Mr. Ivy at a later date, but to continue with the docketed matter that I was working on.
And that's totally fair, I think. But as far as NOG knows, it sends this email, it sends these 3 well plugging records. Nobody from staff responds. Is it not fair for it to believe that these were accepted as evidence of compliance as of fourth quarter 2021?
I don't like to assume anything, but I would agree that may be the way he took that email. Yes.
And in fact, I don't believe that NOG, before the initiation of this docket, had ever been told it wasn't entitled to credit for these wells. Is that correct?
Well, I'd like to clarify these wells that you're talking about here. The plugging reports that Mr. Ivy submitted to District 23 for the 18B. And if you could scroll down, I think it was the 23B and the Spradling 48. Is that correct? Those three wells, those plug-in reports that he submitted, I believe it was the 23B, the plug-in report was dated 1957, the well being plugged as a dry hole, which in sense means the operator that drilled it probably said approximately 20 foot of surface casing drilled down to TD, not enough, assuming not enough oil show to complete the well, so they plugged the well as a dry hole. The same is also for the Spradling 48. However, I believe it was 1965 was the plug-in report. Yeah, or is that what that said? 1965 for the Spradling 48. It was also a dry hole, along with the 18B and 57. All three of those plug-in reports that he sent in were for dry holes. And back when this agreement, the compliance agreement was entered, there was a well inventory list sent to Mr. Ivy, and he responded back with that inventory list with those API numbers and those three well numbers as being okay. He did not have any objective at that time. And where I'm trying to go with this, these wells that are there now today that are inactive and not plugged, 18B with API number that's listed, the 23B with that API number, and the 48 with that API number, are wells that are constructed to have drilled later in time, probably the late 70s, 80s. So just because the three plug-in reports had the same well numbers on them, did not have any API numbers, does not pertain to the three wells that are actually on the compliance agreement that was signed, if that makes sense to you.
It does make sense. And I guess the first time that was communicated to NOG was in your pre-filed testimony after its license has been revoked. Isn't that correct?
That I had found that, yes.
It's kind of too late. I mean, the email says he thinks he's got the API numbers. Those API numbers are on the compliance agreement. Mr. Dunning told him, Mr. Ivy, he could turn these in for credit. No one responds to his email. And next thing he knows, his license is revoked. How is he supposed to know what you just testified to if he doesn't hear about it until they're in a contested matter before the commission?
I believe if I would have been the operator, I would have called. We all have cell phones. I could have talked out in the field. But when, it's also kind of, to be honest with you, it's the operator's responsibility to kind of know what wells he has. And when he signs the agreement, those wells were actually physically there, had been to by staff. Staff had actually asked Mr. Ivy if him and I believe maybe the actual owner wanted to meet on site to visit any of the wells, and he declined. So though, I mean, there's no reason to believe that a 1957 dry hole plugged well would still be above ground when these wells that are actually there with those well API number and well numbers were drilled. I'm assuming, I'm going to guess at late 70s, early 80s.
Let's look at exhibit, what I've marked 19.4A. So these are materials furnished by staff in response to a document request number 4. And this is an email between Mr. Ivy I clicked the wrong, I'm sorry, I pulled up the wrong one. 14B is the one I want. So again, this is an email furnished in response to a document request I submitted to staff, document request number 4. These are pages 28 through 30 of that document request. I'm going to ask that this be marked as Exhibit N 19.4B. We've already looked at this email here. This is the email that you indicated to Mr. Ivy that NOG was one well short of compliance in fourth quarter of 21. But you attached a report indicating its progress, NOG's progress under the compliance agreement to this email. And so let's just flash back to N9, the 3 wells at issue with plugging records, the ORD 18B, the ORD 23B, the Spradling 48. That's what's in the email marked as Exhibit N9. This is your report to NOG. ORD 18B is on there. ORD 23B is on there. And the Spradling 48 is right there. So as of March 2nd, when you sent this email, NOG is getting credit for these wells that you now say are not in compliant, correct?
That actual email, that is a reminder letter for the upcoming quarter. And those wells that are on there is what was listed as already coming in compliant. This was the first email that I'd sent for any compliance agreements. And at that time, they were already marked as being compliant. So I actually did not review any of these wells until the end of the first quarter of 2022 with March. But I will agree with you what you stated, that those wells are on that list, and it appears that he had been credited for them.
Yes, I mean, this is an email from you to Mr.
Yes, sir.
Ivy. Yeah,
Yes,
in
sir.
March. And we talked about not knowing about the issue that you testified to with the wells being old and not having APIs, but NOG wasn't told about that until pre-filed testimony. So we're talking about what's going on in March of 2022. And it believes, I mean, is it reasonable for them to believe if it submits 3 well plugging records and those records show up on the compliance report that it was given credit for those wells?
I'm not going to agree that staff didn't respond. I believe Troy Russell, my supervisor, actually responded to him about those 3 plug-in reports, but I do not have a date or anything like that in front of me.
But to get back to my question, is it not reasonable for NOG to believe that if it submits 3 well plugging reports and they show up on the compliance report, that it received credit for those under its compliance agreement?
I'm going to say that it's correct.
We're just about finished here.
Now,
Mr.
can I
Dooling,
point one more thing out with the list that you have pulled up?
it might be best if you let Mr. Marsh do that during rebuttal.
Okay.
But if
Thank
you
you,
want,
sir.
I mean, is it something that you can steer me to?
No, that's okay.
Okay.
Thank-
So this is an email marked as Exhibit N11. It's dated March 3rd, so the day after your email. And it's actually a chain of emails here. So here's your March 2nd email, and here's Mr. Ivy's response. And he's basically asking here, let me zoom in so we can read it. Says the report said we missed a well last quarter, but we turned basically what we just talked about. Indicates that he still believes his license is suspended. talks about wanting to do the development plan down here, which is the EOR project that's mentioned over and over and over again in this correspondence with staff. And Mr. Russell's response here is basically the reason there was only 17 on there instead of 18 is because there was a well that had a duplicate name. Is that correct? I believe.
Yeah, that is correct. The operator claimed the Spratling 18B, which was on the previous list that you showed for the plug-in reports. It was actually counted towards being in compliant for the first quarter of 2021 because the operator reported and claimed that well was in production, which kind of should have been noted that if it's in production in March of 2021, I'm not sure why you would submit a plug-in report from 1957 trying to claim it as a plug well later.
And we believe the reason why there are two Ford 18B wells, I'm going to direct you to exhibit N17, is because there are indeed two Ford 18B wells, correct? There's one here on the draw, and there's one here out here. Real close, but two wells.
What
Correct.
exhibit is that?
N17 of Mr. Ivy's testimony.
And I'm not, do you know where this was taken from? I don't see.
It's some sort of software that uploads KC or KGS data, as I understand it. It's called the Well Finder app.
I'm not too familiar, don't use Well Finder. A lot of times I use Kansas Geological Survey. And then I know that I'm pretty sure that that's not from the KGS website. I would have to research one quick thing. If you can blow that up a little further so you can see the actual API numbers on those 18Bs.
Mm-hmm.
I believe the red is kind of on the one on the right. I'm assuming that is the correct API number. It's kind of drawn through there with the red, but I'd have to go back and try to find the actual, but I can tell you on the left-hand side, that API number, if you see where it's 15099, then it starts with a 70,000 number.
Mm-hmm.
That is actually not a good API number. So I'm not, again, familiar with this software to speak on it, but that 70,000 number, I can guarantee you was never listed on any compliance agreement.
Okay. Well, this is the well that was returned to production. I believe this is the well that was probably plugged over here. The 70.
Well, that well that probably plugged, I cannot verify that because that well, like I say, with the 70,000 number, that is not a good number. So I cannot tell you if there had ever been a well over where that circle's at or not.
Okay. Well, we can move on past that. You had testified earlier about the EOS 1 and EOS I1 well and the EOS 2, basically that NOG. Why don't I just direct you to your testimony on that?
Okay.
If I can get there. This would be in your rebuttal testimony. So we're going down to page 3, line 18. I'll get zoomed in here. So on page, Mr. Ivy states that operator had 3 wells plugged in September of 2021 to meet its objectives. Is that accurate? No, is your response. Operator had plugging applications for the EOS 1, EOS I1 were not actually plugged. And so those are the 2 wells you said that NOG tried to get credit for that shouldn't have. Correct?
Correct.
If we go to, I'm going to call up another report here, and this is a response to my document request. Exhibit, I'm marking it exhibit 19.4A. And so these would be pages 7 through 11 of staff's response to my document request number 4. I'll zoom in here. This is an email from Mr. Ivy to Mr. Dunning, Mr. Allman, Mr. Russell. I believe this is a roustabout. And why don't we just take a second to look at this email?
Okay.
So on September 27, 2021, so in that time period referenced in your testimony, NOG tells staff that it's going to plug those 3 particular wells, the EOS I1, EOS I1, and the EOS 2. I'm going to go now. Let's surf over to your direct testimony and specifically exhibit RD3 of your direct testimony. I'm going to use this because, okay, so this is a report dated March 9, 2022. And the reason for investigation is request from Ryan Dooling, I believe is you, District 3 Compliance Officer. Says plug 3 wells, splitting public reports, yada, yada, yada. So if you go to the very end of this exhibit, it's a 38-page exhibit. We have a map. This is the last page of the report, and it has the EOS 1-1, the Spradling EOS 2, and the other EOS 1. It also has a 60A and a Terwilliger number 1. What do these symbols here, they look like the no smoking logo. What do those mean?
That symbol, it looks like in the legend there on the map, that symbol represents plugged wells.
Plugged wells, okay. So this Spradling 60A is pretty close to this EOSI number 1, and this Terwilliger's number 1 is pretty close to this EOS-1, right?
It appears that way, yeah. I mean, on that map it is, yes.
So NOG, in fact, plugged 3 wells in September of 2021. It just plugged 2 that had different names, at least according to staff, than what was referenced in the field, correct?
That is correct.
Yeah, here's the photo of it, Spradling 60A plugged. Here's I believe this is the CP23 staff's record, September 28, Spradling 60A plugged and abandoned. Go up to this Terwilliger. It's up on page 27 of this exhibit. Plugged. Plugging date on the CP 2-3 or 2-3, number 1, plugged. September 28 again, and the EOS P21, sorry, page 21. Here's the EOS 2. That one we got right. It was plugged. CP 3 on page 20 of that exhibit, EOS 2, plug 92921. So it did plug 3 wells in September 20. We just, seems like the names get mixed up. Correct?
I would say you're correct that they did plug 3 wells, that they did. Yes, sir.
Okay. I mean, isn't part of the issue out here with this lease is you have 60 or something wells on 100 acres of land and they're real close together. Some of them have casing cut off, some of them have pumping units on it. It's not apparent once you're out in the field which well is which, is it?
I would think if I was the operator, I would know which well is what. I mean, I am not the operator. So if I was to arrive on that lease for the very first time in my life, it could be non-apparent what well is what, but after doing some research and searching, I would think I would feel comfortable getting on the correct well.
Well, I'm going to direct you back to exhibit N 19.4B, which is again staff's report. It seemed to be satisfied at least as of March 1. This is the report attached to your email. So this is your report that those wells were indeed plugged, even though they ended up being different wells, correct?
I left those wells on there as the EOS 1 and the EOS I-1 because staff had not had time to verify those wells were actually plugged. I'm going to be honest, we operators report to us daily on activities that are done. There's no way we can have staff at every activity the day it's done, but we ask staff to go verify to make sure. So the EOS I-1 and EOS 1 were put on as compliant because of the CP1 application filed by the operator and the operator calling the district office to schedule the plugins. However,
Oh, go ahead.
However, those wells did not get plugged. So later I removed those 2 wells because they were not in compliant because the operator plugged 2 other wells.
The outcome's the same, right?
No, sir, it's not.
It's not.
No, because one of the wells that the operator plugged wasn't even on their well inventory. So I don't know. There is a clause in the agreement that they could have requested for that well to be added to the compliance agreement, but the operator never sent a request to add that well. So.
Okay. But as of this date, operator believes that it's doing what it's supposed to do with respect to those wells, notwithstanding the name discrepancy, correct? Because this is what you are telling them.
Yes, sir.
Okay, the last thing I have for you is the development project that NOG had asked to conduct. I mean, there are numerous emails in the record or that will become part of the record referencing this development project to staff, where Mr. Ivy is requesting a meeting with staff to discuss this development project. I mean, specifically exhibits N7, N11, and N16. Staff never really responded to those requests, did it?
Which email are you referring to, sir?
We can go back through them. I mean, there was, well, I'll just do one by example. How about that? That'll save everyone some time.
I was going to say, I know if it'll save time, I never responded to an email regarding a developmental plan. But I don't know which email because this developmental plan has been mentioned since 2019, I believe, in emails. So
Staff's been aware of it since at least 2019, the desire to meet on this plan. Here's in 11. Is that correct? Was that your testimony?
What? Could
That-
repeat?
That staff's been aware of NOG's desire to meet on the development plan since at least 2019.
I don't know. I've seen several emails where operator has discussed putting this development plan in place. I would have to check the actual date when it was first.
Okay. But you've never seen an email where staff responds to that request or even acknowledge?
I mean, I'm gonna be honest with you, I have not seen all of the emails, if you're talking from 2019 to present, because a lot of them I wasn't even involved in, didn't have my name attached to it. So I can't say for all staff. I can say personally myself, I have not responded to an email that has anything to do with the developmental plan.
Did you review the development plan it's a confidential exhibit attached as N4 to Mr. Ivy's testimony? Did you review that at any time?
I might have glanced at it, but I have not reviewed it thoroughly. No, sir.
Does staff have an objection to this implementation of this development plan? I mean, for any reason?
To be honest with you, one of the reason I haven't reviewed it is I don't believe that I could find it. I don't know if that was part of it was blacked out, but I don't even see an N4 exhibit for Nacogdoches.
Okay.
Do you have? I'm
It's-
not asking a question.
We don't need to go through it. The
Okay.
gist, you understand the gist of it is to immediately bring 29 wells, give or take, into production as a combination producer injector for purposes of conducting a water flood.
Well, I don't believe anybody would be objective to immediately bring that many wells into compliance. If that was your question.
No, but that's an acceptable answer. But staff seems opposed to that plan, at least in your pre-filed testimony, and I'm trying to understand why, other than it doesn't fit into the parameters of the compliance agreement for 3 wells a quarter. It requires bringing 29 wells on over the course of 4 to 6 quarters.
I would like for you to point to my pre-filed testimony where that's at, where I say that's not a good thing.
Okay, let me see here. And if I'm mistaken, I apologize. Okay, yes, you're correct. I mean, other than just wanting his license or NOG's license revoked, and being opposed to having it renewed. The staff doesn't actually have an objection to this plan if it were implemented as proposed.
I'm not going to agree or disagree because I have not actually seen the plan.
Okay,
That N4, it was not provided. So I'm not going to answer yes or no. I cannot see that any district in the state of Kansas would be objective to bringing 29 wells immediately into compliance if as long as it did not affect any rules and regulations that are set in place.
okay. I think that's fine. I appreciate that response. And that's, Mr. Dooling, that's all I have for you.
Thank you, sir.
Thank you.
All right. This time, we'll move on to commissioner questions. Chair Keen, do you have any questions for this witness?
I do. Good morning, Mr. Dilling.
Morning, Cherokee.
I'm trying to figure out where we are right now. So let's try to cut to the chase together if we can. Mr. Marsh indicated in his opening statement that The staff believes that currently, under the terms of the compliance agreement, the operator is 14 wells behind in resolving the compliance issues. Is that also your testimony?
That is correct. At the end of the third quarter of 2022, Nacogdoches is 14 wells shy of being in compliance with the compliance agreement.
So as of 9/30/22, in your opinion, under the terms of compliance agreements, they are 14 wells behind in compliance.
That is correct.
Okay. In your opinion, when was the last time the operator plugged any wells under the compliance agreement or returned to service any wells under the compliance agreement?
I don't want to misspeak, so let me look to see if I have that. I believe it would have been in the second quarter of 2021. No, the third quarter of 2021, I'm pretty positive is when the operator plugged the EOS, I believe it was -2 and the Turbolinger #1, which both wells, those two wells were on the compliance agreement.
Those were the last wells the operator plugged under the terms of the compliance agreement. Is that correct?
That is correct.
What was the last?
As far as my knowledge, that is the only two wells the operator has actually plugged per the compliance agreement.
Okay, so let's look at the return to service side of it then. When was the last time the operator returned wells to service such that they then thereby became compliant with the terms of the compliance agreement?
I believe that will be June, the second quarter ending June 30th of 2021, I believe are the last. The Spradling 51 was reported July 6th of 2021 as being put back into service. And I definitely don't ever want to misspeak, but I believe that is the last well that I've noted that was put back into production or supposedly put back into production.
Okay. Now, when wells are plugged pursuant to compliance agreements, are the operators still obligated to file CP1 report of plugging and provide the accompanying documents with respect to cementing?
Yes, sir. Operators are required to file a CP1 plug-in application before the well is plugged. And then after the plugging, the operator has to file a CP4, which is actual plug-in report.
Aside from these well plugging records from 1957, are there any more recent records well plugging with respect to the ORD 18B, the ORD 23B, or the Spradling 48?
No, sir.
Now, one of the documents that Mr. Slider asked you to opine about was, it appeared to me to be a field report. I think it was designated as a CP 31. Is that a field report?
Could you repeat that? CP what?
A 31, I think it was. It was hard for me to see. It was down at the very bottom. It was signed by Dallas Logan.
I'm going to guess that was probably a field report. It was signed by Dallas Logan.
I believe it was.
Oh, that was probably the CP23.
Okay.
That is the staff's plugin report.
Is that a follow-up report?
That when a well is plugged, the operator has to file a plug-in report along with staff has to file a plug-in report. Operators required to file a CP4, staff's required to file a CP23. So the CP23 is a report that staff filed for the well, probably for the Twirlinger #1 and the EOS-2.
But not for the other two.
Let me check. You're talking about for the other two that were not on the compliance agreement?
That's right.
I am sure staff filed one. I think there was only 3 total plugged. I'd have to look at this field report. If you have just a second. Okay, so there's a CP23 filed by Dallas, I believe, yeah, Dallas Logan for the EOS-2. CP23 filed for Dallas for the Twirlinger #1. And Dallas filed a CP23 for the Spradling 60A, which is not on the compliance agreement. So yes, staff filed plug-in CP23s on all 3 wells that were plugged.
Okay, let's just see if we can be sure that we're clear about the forms and which forms are which. The CP1 is a well plugging application form, right?
That is correct.
And the CP4 is the well completion, plugging for completion form in effect. Is that right?
That is correct. That the operator fills out.
Okay. And notwithstanding whether the operator provides notice to a field agent, they still have to file the CP4 for every well they plug, do they not?
That is correct. Supposed to, yes.
And in the sequence of how wells appear in your compliance reports for these compliance agreements, at what point in that process do you actually make a change designating that a well is either been incompliant? I mean, how do you dovetail the receipt of the CP4 with your internal reports?
I cannot state how Mr. Ullman used to do it. I can state how I've done it since I've taken the job. If an operator calls and reports a well to be plugged and it's plugged, I try to have staff verify it before that report goes out. During that time frame when them wells got plugged, there was a lot going on in our district on other dockets, and we did not have the staff to go verify to make sure the wells actually got plugged. As most of our contact with operators, we deal a lot with operators when, reporting what they do, and not very often we find that it wasn't done. So as far as when we do this update, it's required every quarter we do update all the compliance agreements. And sometimes if the operator waits to the last day of the deadline of that quarter, I try not to count anything until I verify that it is plugged. Unfortunately, these 2 wells were added for the CP1, and it was called into the district office to be plugged. So John counted those towards the objective, and it just took until March of 2022 before verification to find out the wells did not actually get plugged.
Okay, all right. Mr. Dooling, let me ask you this. Do you know of the total number of operators licensed by the commission, how many operators are active in eastern Kansas within District 3?
Oh, boy. I do, how many operators District 3 has that is active?
How many active operators in District 3?
I cannot, a lot of active operators in District 3, but I can't give you a number. I do not have that.
More than 500?
I would say yes.
More than 1,000?
Boy, I do not know.
No, I won't ask you to. I don't want you to testify on anything you don't have fact specific information about. The point I'm getting at is if an operator sends you an email and says, I got up this morning and I just don't believe that I need to comply with a certain regulation of yours. And unless you tell me I do, I'm not going to comply with it. Does that obligate, with all those operators you have, with all the email traffic and all the other business that you're trying to do, does that obligate, in your opinion, the state to provide an affirmative response to that kind of an email?
No, sir.
And why is that?
If I got bombarded by 1,000 emails, if there was 1,000 active operators in District 3, it would take me days to get to respond to all of them. And that's without 100 phone call interruptions, other activities that I'm not actually witnessing, but trying to get field staff in the right direction. There would be no possibly way to respond to all of them in a timely fashion.
Right.
Thankfully, we don't get 1,000 emails a day, but I still get plenty.
Actually, is it the state's responsibility or their operator's responsibility to make sure that they are compliant with what the state requirements are? And if they have concerns about those, to take the initiative to actually ask the state directly and don't just suggest that by non-response, we therefore have confirmation.
That is correct. It is the operator's responsibility to be compliant with all rules and regulations.
Okay. How many compliance agreements roughly are being administered right now by the District 3 office, if you know?
I do not know the exact number, but more than 20 are actively active. And I'm going to say that don't actually include even settlement agreements. That's just directly compliance agreements.
Okay. And so I presume do you believe that you're fairly conversant with the terms of these compliance agreements as they are as they exist presently?
Yes, sir. And
the differences between the compliance agreements.
Right there. That's what I was getting ready to tell to. There's actually different, we've strived and gotten better as years went by with compliance agreement, and the template has updated. So, each compliance agreement, if there's an issue, I always go back and look at the actual template that compliance agreement was drawn on to make sure, nothing that I'm following the guidelines set and then its actual compliance agreement. But I feel that I'm, pretty confident that I understand the terms that are in all those agreements.
All right. Under the terms of these compliance agreements, and let's take the compliance agreement specifically before us right now with respect to this operator. Do you feel that you're pretty conversant with the terms of this compliance agreement?
I believe so, yes.
So my question is this: does the suspension of an operator's license suspend the operator's compliance commitments under the compliance agreement?
No, sir, it does not.
So you're saying there's no provision in the compliance agreement with respect to this operator that says in the event that your license is suspended, that all of these compliance requirements that are on the timeline fixed by the compliance agreement are also suspended.
I am not aware of one. I do not believe it's in there.
Do you know of any compliance agreements where that does appear?
No, sir, I do not.
All right. Mr. Dillon, let's take a look at page 6 of your direct testimony. John, to the extent you can bring it up, it's unnecessary. We don't need to do that. Let's do it in fairness to all parties. Let's go ahead and do that.
One moment, you're asking for Mr. Dooling's testimony?
Page 6 of the direct testimony of August 26th, 2020. Page 6, please. All right,
Can you guys see it? I'm having a little bit of difficulty myself here. Very good.
You could maybe enlarge it slightly. I can read it. That's good. If others can't, please speak now. I'm looking at lines 3 through 6. And again, I'm trying to reconcile the numbers here, Mr. Dooling, of exactly where we are. As I understand what you're saying here, especially on lines 5 and 6, that you're testifying that the basically staff records indicate that the operator has, as I'm reading that, it's 11 wells that they haven't taken action on that they should have by the end of the second quarter of 2022. Am I reading that correctly?
That is correct.
And then I'm juxtaposing that with your earlier testimony that as of the end of September, the third quarter of 2022, there are 14 wells behind. That would be the additional 3 that were added during the third quarter that were not plugged. Is that right?
That is correct.
So that's how the math would work out on that. All right. Let's stay with the same direct testimony. Let's turn to pages 8 and 9 if we could. And specifically, yes, that's captured it well. Nice going, John. That's good. It has to do with the question that begins on line 21 of page 8. That's what I want to focus on. More specifically, what I want to focus on is this return to service option in terms of compliance, which is an option, it appears from the records that we've gone through with Mr. Schleider's cross-examination of you, is the predominant way that this operator has sought compliance. Isn't that correct?
That is correct.
So if we go up to, we can go on to page 9 now, lines 1 through 4. On line 1 begins, however, each of the 11 wells that were returned to service has subsequently fallen back out of compliance. These wells have fallen back out of compliance because they have been inactive longer than 90 days. Do you see where that is?
Yes, sir, I do.
So do you know? So these wells were returned to service, claimed to return to service by the operator. Now, according to your testimony, they have become, they are now inactive. Do you know what caused them to become inactive? Was it the absence of surface equipment, or what caused them to become inactive?
That's correct. Staff field reports show a lot of the wells are not have any equipment, and the ones that do have some equipment are not totally equipped for the return of production. There's not any electric that runs from the actual meter that comes to the lease to any of the wells that I'm aware of. Operators continued to keep the meter electric coming to the meter, but there's no way to produce the wells unless I guess if you're going to go put gasoline powered motors or generators to the lease, that they cannot flip a switch and begin production on any of those 11 wells.
Mr. Dilling, I believe that concludes my questions. Thank you very much for your responses.
Thank you, sir.
Commissioner Duffy, do you have any questions for Mr. Dooling?
Yes, just a few. And I'm just going to follow up on that line of questioning from Chair Keen. So when those 11 wells that in your testimony on page 9, the pre-file testimony that we were referencing, when those were in compliance, did they have electricity running to them at that time? And did staff observe that they were in compliance and that they were working?
I do not know the answer to that question. I did not work that area during that time. I assume that staff verified as many of the wells as they could to be in production, back to service. I know there was some notes that I don't know if it was one or more than one well that was in production, maybe by a gasoline powered motor. I do not believe there's been electric actually running to the wells and any electric usage for more than 2 years.
Okay, so are these gasoline powered motors considered permanent when the operator brings a well into compliance and hooks up the gasoline powered motor? Is that a permanent motor for that particular well, usually in District 3?
Not usually, no.
Okay, so would our staff have sanctioned the compliance on wells that were operating with these temporary gas-powered units?
Could you repeat that one more time?
Would staff, and I'm not you, but the other staff that goes out and verifies the compliance, right? Would they have certified that the particular well was compliant if it was being operated at that time by a gas-powered unit?
Yes, as long as the well is producing and fluids and going through, you know, being transported to the tank battery site, it would be counted as incompliant and producing because they're actually producing fluids.
Okay,
That would be compliant, yes.
okay, and further, we would also verify the compliance because on production records, it would show that it's producing, correct?
It should, yes.
So is it usual or unusual in District 3 that wells are run, that wells are operated with these temporary gas-powered units?
It's not a normal practice. I'm not going to say there's no wells because there are a few wells that are operated that way. A lot of those are gas wells that I'm aware of that has, you know, they're actually ran off of natural gas motors, not actual gas or diesel powered motors. But it's very, very limited and very unusual for any operations in District 3 to be ran by a gas powered motor.
Okay, so let me go on. I believe the operator also stated, and I don't have the page or the reference, that some of the motors had been stolen. So were these the permanent non-gas motors that had been stolen? Or what do you know about that?
I did read that in his testimony, I believe, where he mentioned that they was having problems with theft. I do not know, and I, you know, we have a lot of leases in the state of Kansas, and there is theft from time to time, but normally an operator is visual and on their lease daily to produce, check to make sure there's nothing spills or anything like that. And I mean, I can't testify if they did or did not have motors stolen, but I'm assuming the motors, if there was some stolen, it was probably electric motors, not these gas powered motors.
Okay, do you know if when these electric motors are stolen, do the operators file a theft report with the county sheriff to indicate that?
I'm sorry, go ahead.
Yeah, I mean, do you know, do they file an incident theft report with the county sheriff?
You know, I don't know if they do or not. I know if I was an operator, I definitely would file, you know, a report, just not only for what has already been stolen, but to try to get people, you know, sheriff department to start patrolling to look for suspicious activity on my lease if that was to happen.
How much do, Mr. Dooling, how much do these motors cost theoretically? Again, noting they're being used in District 3.
Ma'am, I apologize. I do not know what a motor actually costs. I'm not in, you know, that line of business. I'm going to take a stab and I might be way off, but I'm going to say $300 to $500.
Okay.
And I might be wrong, but that's my estimation.
Okay. All right. Fine. Thank you. I didn't know whether it was 10,000 or like you're saying $300 to $500.
I would say it was more to that amount.
The lower end.
The lower end, yes, ma'am.
Okay. So because you're the compliance person and you're familiar with District 3 and other capacities, are you aware that since COVID that there is this shortage of getting motors to the operators in this area? Is that part of the supply chain shortage?
You know, I would probably tend to say that it's like anything else. There probably was a shortage of being able to get supplies. I mean, we've seen it since COVID, it just from the grocery store up, different things, supply chains has been down. I believe in today's market, there's readily available supplies for the oil field that you can go local stores and get now. But I can't deny that the fact that there was probably a time there that there could have been a shortage of being able to get some motors. But we had a lot of operators buying supplies and continued to produce, not only in District 3, but the state of Kansas, upgrades that they were able to get supplies. So I would tend to believe that they would be able to find some somewhere.
Okay. Let me ask you this. Were you a party to the signing of the compliance agreement? Were you in the position when that agreement was signed that you currently hold?
No, ma'am, I was not.
Okay, so you probably would not be aware of the discussion when a compliance agreement is developed, of the discussion that would ensue with the parties about which wells, how many a quarter, all those necessary things that go into the agreement. Is that correct?
When this one was done,
Yeah,
yes, no, I did not have anything to do with the interactions with this compliance agreement.
okay, but let me ask you, and since you have been in this role as compliance officer, if the operator was thinking about doing something such as the water flooding project, which sounds fairly complicated and there's several moving parts. You got to make sure you got all the wells identified and you know which wells are going to be, the injection wells, and to actually be successful. Would that discussion of water flooding and bringing into compliance a whole bunch of wells, would that have been a part of the discussion of a compliance agreement, do you believe?
It might have been discussed. I can't attest to that, but normally on a compliance agreement, we want information from the operator. What's your plans? Are you looking, to plug these wells, actually get the field back into production? But to actually have a developmental plan that's been spoken on for quite some time now, I don't believe that would be just the sole decision factor on whether a compliance agreement would be put in the works or not.
Okay. So, we're talking about, it appears this operator has a pretty finite presence in 2 counties, correct? Labette and I'm not sure what the other county, or is it just one?
I'm only aware of Labette County.
Labette County, that's true. Okay. So, not a huge operation, a pretty, but not small. So the fact that the statement earlier was that this had been discussed, this water flooding, the project had been discussed since 2019. I really struggled to find in the testimony and the exhibits where at the time of the compliance agreement, this was, wouldn't that be the appropriate time to talk about this project?
I don't want to set exact date 29, but there were several emails that I was reading through that talked about the developmental plan. Several emails, I mean, one in particular back early on stated that the developmental plan had been completed and ready to, I believe it was in March of 2020, but I don't want to veer off. What was the actual question again? I mean, about this developmental plan?
Since this plan has been discussed since 2019 or shared, I'm struggling to find where in the discussion of the compliance agreement that there was not some consideration given to making this a part of or whatever. I'm just not, and if there is something in the testimony that I need to be directed to, I wish somebody would share that with me, but
I do not believe there's anything there. I mean, the developmental plan would not be part of the actual compliance agreement order.
okay,
What we want to do with compliance agreement is we want to get wells back into compliance, whether we plug them, produce them. And when we set these guidelines, so many wells per quarter, you have to do these things. The developmental plan talks about inserting a water flood. I'm assuming, I don't have that, I don't have that exhibit about the development water flood, but those wells, once they got them, if they got them MIT approved for injection and permitted and all that, and got them put into service, those wells would actually count towards that compliance agreement as long as those wells were part of the original compliance agreement.
okay.
So I don't know if that answers your question, but there's not.
It helps. You're
Okay.
providing some more meat on the bone for me. Let me ask you this. How often when a compliance agreement is signed, and I know we have, I have been a signator as a commissioner to many, and I don't take these lightly. And I am concerned, when there's just 3 a quarter and it goes out several years, but I understand you're just plugging away, you're chugging away. What percentage would you say on these compliance agreements are the wells actually being returned to service?
On this one or overall?
Overall, in District 3?
In District 3, we have a very high percentage plugged that are on compliance agreements.
So more are plugged than actually returned to service in compliance?
That is correct.
Okay. Of those that are returned to service in a compliance agreement, since you've been in this position, how often do you see an operator's wells fall out of compliance after he's returned them to service via the compliance agreement and then let them fall back out of service?
Not very many. And if they do, for some reason, fall back out of compliance, majority of the operators file the proper CP1 application, CP111 application, for temporary abandonment until they can put it back into production or plug it.
Okay, so then they would just file their CP1. Okay.
CP111.
Oh, 111. I'm sorry, I didn't see on my note there. Okay, so in all compliance agreement is the 30-day where if you got a problem, you got 30 days to contact our office. Is that standard language?
30 days before the deadline. Which part of the agreement are you looking at?
I'm looking here. Oh, wait, it's in exhibit N2 of the operator. I'm sorry, it's paragraph 3. If an operator seeks a time extension for any deadline under this agreement, the operator shall request such an extension at least 7 days prior to the applicable deadline. So there's a 7-day, but the operator may receive, upon approval, an extension for 30 days. So did this operator file to seek time extensions for any of the deadlines under this agreement?
Not that I'm aware of.
Okay. Thank you, Commissioner French, and thank you, Mr. Dooling, for your time today.
Thank you, ma'am.
Well, Mr. Dooling, I have no questions for you, but I think I'm going to pause at this time. We've got redirect, and then I think I'm going to allow recross optionally, given sort of the extensive commissioner questions. But we're well into the lunch hour at this point. We haven't taken any breaks. Let's plan to take a 30-minute break for lunch and restroom and whatever anybody needs, and we will reconvene at 1:05. We are now off the record.
Parties, a reminder, we are still live streaming, or we may be live streaming, and so you'll want to keep yourselves muted and off video until we're on the record again.
All right. Looks like we've got Mr. Duffy, Mr. Dooling. Commissioner Keen is here. We have Mr. Schlatter. All right, John, are you with us? All right, very good. We are back on the record in this proceeding, and we were just concluding commissioner questions for Mr. Dooling, and I understand we may just have a few more questions from Commissioner or Chair Keen. And so, Chair Keen, let me just turn it back over to you if you do have questions.
Thank you, Commissioner French. I appreciate it. I'll try to be brief. Ryan, I want to cut to the chase a little bit on these wells that are under this compliance agreement. Some detail about these wells. Are all of the wells under this compliance agreement alternate to cementing completions?
As far as I know, I believe they are. I haven't looked at every single well construction. I primarily looked at the ones that were plugged and ones that were trying to be claimed for the compliance agreement that on the plug-in reports to see how they were constructed.
Do you have information available there that will tell you what the age is of the oldest well on this compliance agreement?
No, I do not.
That's pretty important. I'm trying to flesh out, to be very candid, the practicalities of the polymer and water flooding that the operator is proposing here. And that's pretty important, the age of these wells and this question about alternate to completion. That's pretty important. Because a follow-on question to that is, are any of these wells slim holes? Or are they all slim holes? If you don't have the information, can you find the information and give us that information, or have some of your associates there at the district office give us that information before the end of the hearing?
I can try. Can we step away for a minute to where I can make a phone call so I can let them know to look?
Commissioner Friends, I would appreciate it if we could do something like that. How, just briefly. Ron, I'm thinking that the information I'm asking for, you need go no further than the file on this compliance agreement, because you're going to have that documentation is going to be on there for these wells. You follow what I'm saying? The age of the wells, whether or not they're alternate to completions, and what the casing is in each one of these wells.
Chair Keen, will you have follow-up questions, or do you simply want the answer to that question?
I would have follow-up questions depending upon the answers to those questions. So if we could just maybe go ahead, dispense with Brian's testimony, have him go about the process of doing the best he can to come up with these answers. And
Is this something, Ryan, that you think you could handle with a 10-minute recess? Or if you're not that confident, we can go ahead and move into additional questioning.
I could I mean, there was no reason I asked for a short break to make a phone call. Was I was going to call district office to have them start trying to gather everything that we would have a record on. I don't believe there's anything in my testimony that would tell me the exact age of each individual well of the 60 wells on the compliance agreement.
No, it's not. And I'm not asking for some universal de novo research effort here. I'm just asking that somebody go back through the existing file that you have that led to the ultimate grant of our approval of the compliance agreement, and just provide us with some idea of whether the age of the wells, okay, whether or not they were alternate to completions. You follow my logic on this?
I do follow your logic, and I believe
the casing size. Well, how are they cased?
right.
Chair Keen.
Yes.
I believe Mr. Ivy may have the answer to those questions.
Okay.
If you would like to ask those to him, and we can maybe reserve Mr. Dooling's some supplemental testimony later if it's out of line.
That's fair enough.
Yeah,
That's a good suggestion. Let's do that.
let's move forward with that. And if we don't get the information that Chair Keen needs today, maybe we can accommodate some process for the parties to file that information into the record as a late filed exhibit.
That's fine for me. If that's, if Mr. Slider finds that's acceptable and Mr. Marsh, that's fine with me.
Chair, do you have any further questions for this witness?
I do not. I appreciate your indulgence with these questions. Thank you.
Mr. Oh, go ahead, Commissioner
French,
Duffy.
I do have one for the witness, and I thought of this over the break. So let me ask you, Mr. Dooling, when you notified the operator that he was out of compliance and or let me put it this way, with a license suspension, does that mean the operator can no longer continue to plug wells on his leases that are included in a compliance agreement?
No, I mean, they can still hire contractors to plug wells on them leases.
Or put them back into service? Either
Correct.
one, they still have the ability, even though their license has been suspended, to continue work to satisfy that compliance agreement.
Correct. They just cannot produce anything.
Okay, thank you very much. Thank you, Commissioner French,
Yeah.
for that indulgence.
All right. I believe at this time we'll move on to Mr. Marsh for any redirect.
Thank you, Commissioner French. Mr. Dilling, so how does a well get on a quarterly update report?
As being either to be shown that's being in compliant.
Yes.
The operator emails or sends a letter notifying us if they put them into production. It says they have to notify us, and then we typically try to verify that the well is back into production. At that time, we will change the status to producing and put in our database that it is back into production. It has become compliant. Obviously, if it's plugged, we put that we verify that it's plugged, and then we put it down on our database as being plugged and in compliant.
So the operator reports it, and does staff ever show a tendency to take an operator at its word and show good faith?
Yeah, I mean, we deal with a lot of these wells, and without good faith from the operators, we would have a hard time ever getting these reports done in a timely fashion. It doesn't mean that we don't go back and check to make sure that the wells are still in compliant, if they'd return them to service or if they actually were plugged. But every day we work with operators, and majority of the time, good faith, we have to have that from operators with the staffing that we have.
And would you say it's more important for a well to be listed on an update report, or for the well to actually be brought into compliance with the commission's rules and regulations?
It's definitely more important to be brought into compliance with the rules and regulations.
Okay. Now I know Mr. Schlatter showed you a couple of documents concerning 3 wells that operator claims were plugged back in the 50s and 60s. Do you recall those documents or recall those wells?
Yes, sir.
And were those wells the Ord 18B, Ord 23B, and Spradling 48?
That is correct.
Okay. I want to take a quick look at this compliance agreement, if I may. Take a stab and make sure I have it. Is that what everyone sees, the compliance agreement?
Yes.
Yes.
Okay. Now, for paragraph 1 of the compliance agreement, it says operators responsible for the 60 wells on the attached list. And it says all of the subject wells are out of compliance with KAR 82-3-111. Is that correct?
That is correct.
And what is 82-3-111?
It's a temporary abandonment.
It's the temporary abandonment regulation.
That is correct.
And so how does an operator bring a well into compliance with that regulation?
If a well is out of service for more than 90 days, operators required to file an 82-3-111 CP-111 form notifying the district that the well is temporary abandonment. That application will be reviewed by district staff and either approved or denied.
Okay, so they can file a temporary abandonment form, or is there other ways that they can bring the well in compliance with that regulation?
Sure, they can either plug it or return it to service.
Okay, so if a well was plugged back in the 50s or 60s, is that well really out of compliance with 82-3-111?
No, not if it's plugged.
Okay. And I mean, that would apply even if a well was plugged in 2019 in this instance, correct?
Well, yeah, that is correct. The compliance agreements, we do not put plugged wells on compliance agreements. All the wells that's listed on compliance agreements are mainly wells that are out of compliance with 82-3-111.
And then looking at paragraph 2, it says, by September 30th, 2020, operator shall plug, return to service, or repair and obtain temporary abandonment status for 3 of the subject wells. Does it say anything about past operators performing these actions and counting towards the agreement?
No, sir.
Okay, thank you. I know there's also discussion about the wells that Nacogdoches did return to service. And if I remember correctly, those wells have subsequently fallen out of compliance with 82-3-111.
That is correct.
And how did they fall out of compliance with that regulation? Do you know?
Well, yeah, after they return them to service, the equipment is not still on the well, cannot be produced. And that reg states that it has to be capable of production to be considered a declaratory well. And so that they're back out of compliance with the 82-3-111 reg.
So they're removing the surface equipment from the well and basically returning it to inactive status. Is that correct?
That is correct.
So would staff really trust an operator to implement a water flood plan whenever an operator has a history of only temporarily returning wells to service?
I broke up a little bit. Could you repeat that, Kelsey? Please.
I'm sorry. Can a staff really trust an operator in this instance to implement a water flood plan when that operator has displayed a history of only temporarily returning wells to service?
It would not be on good faith. I mean, we would definitely have to, use staffing to make sure that everything was put in by the rules and regs, if that is what you're asking.
Okay. And I guess the last question I have is Nacogdoches in compliance with all requirements of Chapter 55 of the Kansas Statutes Annotated, all commission rules and regulations, and all commission orders and enforcement agreements?
No, sir.
Okay, thank you. No further questions.
All right, thank you, Mr. Marsh. Mr. Schlatter, since there was pretty extensive commissioner questions and then some redirect, I just want to give you an optional opportunity if you have any recross.
Thank you. And I'd kind of like to address that in two manners. There were some questions asked to Mr. Dooling that he didn't know the answer to because he wasn't, party to negotiations and the compliance agreement around prior to 2022 on some of these enforcement issues. I think maybe the way I'd like to address those is, if you would allow me to, is a brief supplemental rebuttal through Mr. Ivy, who does have firsthand knowledge of those things. He signed the compliance agreement. He participated in the negotiation. He knows about the theft. He knows about the cost of equipment. When these wells were shut in. I think maybe I would like to address those that way. And I just have some real brief recross from Mr. Dooling on one thing he just said.
Well, I don't think I'm going to totally allow additional rebuttal, but what I will do is, you've given an indication now of what may be within his knowledge, Mr. Ivy's knowledge. And so to the extent commissioners or other parties want to ask questions on those items of Mr. Ivy, it'd certainly be fair game for them to get them answered at that time.
I think it's only fair. I mean, Mr. Dooling was speculating as to what actually happened. Mr. Ivy actually knows and can provide the factual answer.
Mr. Marsh, any response?
I was kind of thinking along the same lines as you, Commissioner French, that, the commissioner, it's been common in the past that commissioners ask similar questions to both witnesses. So this seems like a lot of these questions could be done once Mr. Ivy's been sworn onto the stand and after cross-examination.
I'm going to find at this time that it would not be precedential just to disallow additional rebuttal. Mr. Dooling, I think, has responded and perfectly caveated the limits of his knowledge. So, that is where things stand. But if parties wish to ask their questions or commissioners wish to ask their questions of Mr. Ivy, I think that would be appropriate.
Okay.
Do you have additional or any other recross?
Yeah, real brief on one discrete topic. If I may. Mr. Dooling, you just testified that you rely on operator email or report as to what wells are in compliance and what wells are not under a compliance agreement, correct?
Partially is what I said. Yeah, we rely on good faith from the operators. We eventually try to go to every well that's been returned to service or plugged. But at the time, a lot of operators wait till the last day to fulfill their quarterly objective, and staff may not be able to be there if it's, they might have other obligations, other field activities that they're at.
Well, it seemed to me the implication was that staff relied entirely on NOG to tell it which wells were in compliance and which wells were not. I don't think that's correct. Do you think that's a correct statement?
Could you repeat that again? I'm sorry, it broke
The
up.
implication in your testimony was that staff relied entirely upon NOG to tell it which wells were in compliance and at what time. At least that's how I perceived your testimony. Is that correct?
Yeah, it is the operator's responsibility to report to district staff which wells that they are putting back into service or plugging for each quarter. That is correct.
I'm going to show you some staff reports that were furnished in discovery that I have not pre-marked, that I think kind of underline the point that indeed staff reviewed these wells and found them to be producing. That wasn't a fiction that NOG created. The first one is this report, and it's dated September 30, 2020. It was prepared at the direction of John Almond, the District 3 compliance officer, and they looked at 3 wells to see if they were producing in compliance with the agreement. See, here, determine status of 3 wells that are on agreement. References the 3 wells, and there are pictures of the wells. This actually works pretty good if you do it in like a flipboard, but here's the first one, 27B. It goes, see, you go like that, it's producing. And that was the purpose of taking that picture. So that's one well that staff confirmed was producing. Here is the Spratling 58. And look at that, it's producing. Got a staff member out there observing it, September 30th. Here is the 63 well. Same thing, up and down, it's producing. Staff confirms the well is producing. Here's a map. Here's another report, 12/31, the end of the second quarter. Determine the status of 3 wells that have been produced. At the 32B, the 7, and the 16B. There we go again, back and forth, pumping. That's the 32B. Here's the number 7, back and forth, producing. 16B. So I think that's a sample here. The same deal here. I'm not going to belabor the point. It appears that as to the wells that were brought into production, wouldn't you agree that staff did in fact observe these wells producing and put them in a report?
Yes, sir. I would agree with that.
Okay. And one last thing here. We talked about this during your testimony, but I think it's worth revisiting very briefly. This was when that NOG fell 1 well short of its compliance objective, at least according to staff at the end of the second quarter. This is what it got in the mail from the Kansas Corporation Commission. Until your license is reinstated, it is illegal for you to conduct oil and gas operations. Now, you previously testified their license was never reinstated after this date, correct?
And that's correct.
And so why is it, and bear in mind, this letter is dated after the date of the compliance agreement. In fact, it's a full year after the date of the compliance agreement. Where is it that, how is NOG supposed to know that this letter doesn't mean anything under the compliance agreement when all of its wells that it has in Kansas are operated under this compliance agreement?
I guess I don't understand your question.
How is NOG supposed to know, as you testified, that it can ignore this letter and continue under the compliance agreement when every well that operates in Kansas is under this compliance agreement?
That letter says you cannot conduct oil and gas operations. That does not say anything about allowing contractors to plug or return wells to where they are capable of production.
Okay, so it's your testimony, as long as you're doing it through a vendor, you don't have to follow this rule?
You cannot produce oil or gas while under a suspended license.
Okay, I'm referring to Exhibit N1.
Yeah.
I'd also like to get back to this March 2nd letter that was part of the compliance order. I believe it's N18 or will be marked as N18. This is the same day that you told them that you sent NOG an email saying that they were out of compliance with their fourth quarter obligations. And this letter says something along, that your license is currently suspended, remains suspended. So it still thinks its licensor is suspended. It still thinks it's illegal to conduct oil and gas operations in Kansas. There was one other email one other letter I wanted to look at. It's the March 7th email that basically says you have to shut in all your wells. So if NOG is obligated as of March 7th to shut in all of its wells, how can it remain in compliance with KAR 82-3111, which says you have to keep producing the well?
Well, if it's suspended for more than 90 days, then it would be in violation 82.3.111. At that time, they would have to submit TA applications for temporary abandonment.
To file a new application. And then, as we talked about earlier, if that well falls out of compliance, then there's supposed to be a new enforcement action. It's not supposed to roll back under this compliance agreement where it can be punished again. Isn't that correct?
That's correct. I don't believe that any of these wells have been.
That's all I have with this witness.
Thank you, Mr. Slatter. Let me just check, since we had a good amount of questioning there. Do any commissioners have follow-up questions? And also, just shot in the dark, Mr. Dooling, do you know if staff has been able to run down the information requested by Chair Keen?
No, but I haven't contacted them.
Very good. Any questions from other commissioners? Commissioner Duffy?
Yes, just real quick. So as we look at the balance of the compliance agreements that operators have with the state of Kansas, and when an operator falls out of compliance, tell me, is there any confusion on the operator's part as to whether they can continue plugging their wells under the agreement versus the language that states in the suspension letter that you cannot continue with oil and gas operations? Are you aware of other situations?
Yes, I do have other situations on different compliance agreements where an operator has fell behind by a well. And he did the paperwork, the CP1, and had a licensed plugging contractor plug the well. And obviously that counted toward it and brought his compliance agreement back into compliant.
Okay. All right. Do they ever pick up the phone and just call and ask directly, or?
Majority of the time,
Would they call you?
yes, that would be their first reach out, is to call myself.
Okay.
This instance is, I do not believe that I've ever spoke with the operator.
Okay. All right. Thank you.
Chair Keen, you have a question?
If I could, please. John Myers, if you could bring up, there is a document we've seen this morning. It was a letter. I think it was toward the end of 2021 from John Allman to Mr. Ivy. It was the letter that indicated to him that he was retiring and that Mr. Dooling was taking his place.
Chair
Could you bring
Keen,
that letter up?
yes, Chair Keen, that's going to be difficult for me to do without knowing which exhibit it is or which testimony was in. Perhaps councils could inform me where to locate it.
Yeah, John Snyder, if you could help us there, I'd appreciate it.
I'm working on it.
Okay. It was a December letter, I think,
I
John.
think it was
of
A.
20.
Yeah. Yes, in Exhibit N8. And maybe
Exhibit
I-
N8, and that is the cross exhibits you sent last night, or is that in somebody's testimony?
That's Mr. Ivy's exhibit, and I think I can maybe display it if that would help.
That might be best
Sure.
if you have it. Thank you so much. Apologies.
Who would have thought I'd be driving Zoom at the end of this year? Let's see. And 8. Okay.
Hello.
Okay. If we can take a look at this for just one moment. Yes, this is the letter. This is the letter. Note, I'm asking you, Mr. Dooling, as Mr. Schlatter indicated, it does provide evidence of the fact that you are a successor to the compliance officer responsibilities. That's for sure. But if you look at the first sentence, indicating it's a courtesy email reminding you that you will be required to bring 3 additional wells into compliance by December 31, 2021 to meet your fourth quarter objective for 2021 ending December 31, 21, so forth. Is this not pretty good evidence that the operator was provided with notice of the fact that notwithstanding their suspension, that the obligation to continue to comply with the compliance agreement was still in full force and effect?
That is correct.
Okay, thank you. That was my only question. Thank you for your assistance, John Schlatter. That concludes all of my questions, Commissioner French.
Thank you, Chair Keen. And Mr. Schlatter, you can take down the screen share at this point, I think. All right. I believe at this time, we will just move on from Mr. Dooling. We've had pretty extensive examination. I think all parties have had at least 1 or 2 chances. So, Mr. Dooling, at this time, you may step down.
Thank you.
All right. It looks like we are now ready for operator's witness. Mr. Schlatter, you may call your witness.
Yes, thank you, Commissioner French. Operator NOG calls Brent Ivy.
Mr. Ivy, if you'll raise your right hand, please. Do you swear or affirm that the testimony you shall give today is the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
All right. Thank you, Mr. Schlatter. Witness is yours.
Yes. Mr. Ivy, could you please state your name and address for the record?
Brent Barnes Ivy, home address or work address?
Business address, please.
412 North Street, Suite G as in Gregory, Nacogdoches, Texas, 75961.
Okay, and then for whom are you testifying and in what capacity?
Nacogdoches Oil and Gas, LLC, operator in this case. I am general counsel, attorney for Nacogdoches Oil and Gas, and I am also vice president of operations for the family that owns Nacogdoches Oil and Gas, all of their operations.
And did you cause to have direct and rebuttal testimony consisting of 17 pages of questions and answers and exhibits identified as exhibit N1 through N17 to be pre-filed in this docket?
Yes, sir.
And have you recently reviewed the testimony you profiled in this matter?
Yes, sir.
And do you have any corrections to any of the testimony?
There is one. If you'll give me a second, John, you may have the line. I told you about it. Line, page and line.
I believe if we refer to page 8, line 25, there is a word missing from that sentence.
I'm pulling up my paper. I got a paper copy right here. Page 8, line 25.
Mm-hmm. The sentence said, I think the sentence at issue reads, this had previously been mentioned by staff. I believe the word never is missing there.
Yes, in line 24, it says, on March 2nd, 2022, I received an email from Ryan Dooling stating that in the fourth quarter of 2021, NOG had been 1 well short of compliance. It says this had previously been mentioned by staff, and it should say this had never been previously mentioned by staff. This is the first time we were hearing of it, is what I meant to say.
Okay. So subject to that revision, Were there any other corrections or anything?
Not that I found, no, sir.
Okay, so subject to that correction being made, I would move to have the pre-filed direct and rebuttal testimony of Brent Barnes, IV, be admitted to the record in this proceeding, including the 17 exhibits attached thereto.
No objection.
Hearing no objection, the reference testimony with the correction noted previously will be admitted.
Mr. Ivy, now this testimony was submitted in August of 2022. I'm sorry, September 9th of 2022. Kind of a lot has happened since then. Is there anything that warrants updating in your testimony that you would like to advise the commission of?
Commissioner French, I'd object at this time, and it seems like additional direct or rebuttal testimony that would best be suited to be fit under recross if it becomes subject to, being in line with a recross, or not recross, but redirect situation.
Mr. Schlatter, any response?
There was some things that happened between now and then that I think would help the commission in making a decision in this matter that I think would be worth getting into. I'm not asking to reinvent the wheel, just if Mr. Ivy has, I think, a few comments concerning the status of the development plan.
Can you maybe give me a proffer of generally what you expect to go into here?
Should I do that through Mr. Ivy?
Well, presumably you know where you're going with this, right?
I'm going where Mr. Ivy wants to go with it. I know generally that there's some updates on the equipment, the funds expended, financing of the project itself, generally speaking, but I don't want to testify for him. I think that's the scope of it. That's all.
Frankly, I don't know that sounds like anything earth shattering. So I think let's just stick to what's been pre-filed, since that is our rule. And that's been my previous ruling. So, if obviously if those items come up within the scope of cross or commissioner questions, and then you want to further hone in on them, certainly that'd be fair game. But at this time, let's stick to the pre-filed rebuttal testimony.
Very good. Thank you. Then at this point, I will submit this witness for cross.
All right, Mr. Marsh.
Thank you. Thank you for joining us this afternoon, Mr. Ivy. I guess I'll just start off with a question of, you were the one to sign the compliance agreement on behalf of Nacogdoches, correct?
Yes, sir.
And a majority of the wells that were subject to that compliance agreement are located in section 26, township 32 South, range 17 East in Labette County, Kansas, correct?
I can't speak to the township and right. It's so different than Texas with the counties stuff, but they're just outside of Cherryville in Labette County.
And do you have any reason to believe that information wouldn't be correct?
No, sir.
Okay. And there would also be a few extra wells that were in section 35 as well, correct? Correct.
Perhaps there's an east lease and a west lease on Spradling. And I think there might have been a couple that maybe did extend into a different section.
But those section townships and ranges would be reflected on the compliance agreement?
I think so. They're on our lease. I'll put it that way. And I thought everything on our lease was on the compliance agreement. So I guess yes.
Okay. And you mentioned that there was Spradling East and Spradling West lease. How long has Nacogdoches had the leases covering these wells?
I think mid-90s, maybe. I think is how long NOG LLC has been the operator of those leases, I think.
Okay. And I'll just share my screen real quick just to confirm. So this is what's been marked as Exhibit RD4. It was attached to Mr. Dooling's direct testimony. This is a KGS record. It mainly talks about annual oil production, but it also says view T1 PDF from KCC. Did I read that correctly?
Yes.
Okay, and here is a request for change of operator, transfer of injection authorization, or transfer of surface pond permit. And it says past operator's name and address, Faith Drilling, and new operator's name and address, Nacogdoches Oil and Gas. Did I read that correct?
Yes, sir.
And it says that the effective date of the transfer was January 16th, 1990. Did I read that correctly?
Yes, sir.
Okay, and that was for the Spradling East. And then Spradling West appears to have the same documentation filed, same operator, that was the past operator, same as the new operator, and the same effective date. Does that appear to be correct?
Yes, sir, it does.
Okay, so Nacogdoches has roughly had this lease for a little over 30 years now.
Yes, sir. By that documentation.
Now, in your testimony, and I'm looking at page 4, lines 16 through 17, you state that Nacogdoches brought 3 wells into compliance each quarter by working over and producing the wells. Is that correct?
Yes, sir.
But Nacogdoches has not sold any production since signing the agreement in May of 2020, correct?
That's correct.
Okay. Now, earlier on page 4, you state that there were some unusual circumstances that inhibited Nacogdoches' ability to achieve quarterly compliance, correct?
Yes.
And one of those was pandemic plus related fallout. And just to confirm, you signed the agreement May 28th, 2020, correct?
That is correct.
Okay. Now, it appeared that some of the fallout was trouble finding people to do work for Nacogdoches. What companies did you contact to do work on these wells?
Names are hard to recall. I know Mike Wimsett, who eventually did plug some of our wells, which I think his company's name is W&W Production. I remember his name because we actually got him to do work, but I don't know the names of everybody that we called, trying to get them to come out. So,
Do you recall a rough number of how many different contractors Nacogdoches reached out to?
I don't. I know that Mike gave me, because when he said he couldn't make it, because I think he was actually plugging wells for KCC, he gave me the names of a few people that we called. I also asked Russell Hine, who I know through working out there, for some names and stuff. And then the guy who pumps our wells, Lou Foreman out there, got some names from them, just references.
Okay, and I know one of the other things that you mentioned was the theft of equipment, correct?
Correct.
And just to kind of piggyback off of what Commissioner Duffy was talking about earlier, did Nacogdoches ever file a report with the Sheriff's Department regarding these thefts or this theft?
I did not file one. I don't know if Lou filed anything, but he never told me that he did. No.
Okay, and there's nothing in your testimony that suggests that a police report was filed, correct?
No.
And I want to move on to page 9, lines 14 through 15 of your testimony. There you state that you never met with staff regarding the compliance agreement. Is that correct?
Page 9, what lines?
Lines 14 through 15. Starting with line 14 says, question, did you ever
Yes.
meet with staff regarding the compliance agreement? And the answer, no. And then it elaborates from there. Did I read that correctly?
You did read that correctly, but if you're referring to, did we ever meet with them about the compliance agreement? Yeah, we did when we negotiated it, but I'm referring to that period of March 2022 when Troy Russell had said, yeah, we're going to be meeting to talk about it. That's what I was referring to here.
Okay, so in your testimony, it should really be from March 22 and not ever.
Correct. Yes.
Okay. Just get it on the record. I have what I've marked as Exhibit KCC Cross 2. Mr. Ivy, your email address is brent.ivy@nogtx.com. Is that correct?
Yes, sir.
Okay. On this email dated Friday, August 23, 2019, it says, "Good morning, Ellen and John. I'm traveling to New Mexico today, but would like to discuss the compliance agreement and setting up a meeting in Chanute to go over the plan to increase production at our Spradling lease and get the remaining wells producing or plugged. Please call my cell phone at your convenience. If the phone goes to voicemail, please leave a message with the best number to contact you. And I'll get back to you as soon as I get back to the service." Did I read that correctly?
Yes, sir.
Okay. And then it looks like there's follow-up emails after that. This one from Alan Dunning, Friday, August 23rd. "Hi, Brent. As per our phone conversation this morning, you're willing to meet at the District 3 office on one of these 3 days. Those options were Monday, September 9th, 2019, Tuesday, September 10th, 2019, Wednesday, September 11th, 2019. And I will check to see if this is agreeable with Compliance Officer John Almond and what day is best for him. Is that correct?"
Yes, sir.
Okay. And then later it looks like a date was set to meet on Monday, September
Kelsey,
9th, 2019.
Could you zoom in just slightly on that document?
Certainly. Is that
Getting
better?
a bit small. Thank you.
Sorry, I got a large computer screen, so that helps me out a little bit. Apologize. So a meeting was scheduled for September 9th, 2019 at 10 a.m.
Yes, sir. It looks like that was the date and time.
Okay. And during that meeting, you discussed the compliance agreement and Nacogdoches's plan to increase production on the Spradling lease, correct?
Yes, sir. Myself and Bill Dyer, who has been our kind of boots on the ground for NOG's, all of NOG. We have several companies in different states, Texas, New Mexico, Utah, Arizona. Bill Dyer's kind of our in-house, I guess you would call him operations guy for oil and gas, day-to-day operations. My background is not in that, but he and I met with John Allman and one other guy. It may have been Troy Russell, but it wasn't Alan. I think Troy may have just been in there for a few minutes, but yeah, we came to the office in Chanute and sat down, met with them, and I don't think we ended up signing it. No, we didn't sign it because we didn't sign it for 6 or 7 months till after that.
Right.
Actually, I take that back. We did sign that one.
Right. So it looks like it was Troy that was also the one at the meeting, if this email is correct. But so during that meeting, you did talk about, I'm assuming the plan to increase production would have been the water flood that Nacogdoches has kind of been talking about this whole time.
Could you enlarge that again, Kelsey? I can't see it.
Where do I need to go?
On the one you were just on, the follow-up.
Okay.
Yeah.
This is a follow-up.
Just
what I've
please
marked as-
zoom.
Zoom in on it if you
Yeah.
would.
I've marked this as KCC Exhibit 3. This was a follow-up email after the meeting took place from Mr. John Allman to Mr. Brent Ivy. So Mr. Ivy, I can't remember if you answered the question you might have. I apologize. I got distracted there for a second. But during that meeting, Nacogdoches would have talked about its plan to implement the water flood.
Well, I don't. The short answer is yes, we did talk about our plan to increase production out there. I don't know if it had been decided that it was going to be a water flood at that point in time. We had just hired an engineer to do a new reserve report and then create a development plan for us. I think we did that we'd been talking with them for a bit, but I think we ended up retaining them in September, October of 2019, around the same time we went to Kansas.
Okay. And I know you said this earlier, but you said that you did sign an agreement at the outset of that meeting, correct?
Yeah, and had about so as we had gone through operation since I had kind of, I guess, taken over, we had a guy, Taylor Matthews, who was here kind of that handled all the stuff with Spradling up until middle of 2016 until he left the company, and then I kind of assumed that role. But as far as filing TAs, filing your annual injection reports and all that kind of stuff. What was the question?
Well, it was the question you answer is, did you sign an agreement at the outset of that meeting? And I think that original agreement was for 49 wells.
Yeah, it had like 4, and that's what we thought we had, because we were what I was getting to is we'd been filing TAs and injection reports, basically accounting for, somewhere around 49 wells. And so I think it may have been at that meeting or a day or so later when we finalized it and ended up signing that compliance agreement the first time.
Right. And then after that period of time, staff came back after finding additional wells and had a subsequent agreement for, I think it was 72 wells. Is that correct?
70 something. 77 goes to my head because they gave us a little Google map deal that had wells listed like SPR 1 through 75 or 76, 77, something like that. So there were 70 something wells on this one.
Right. So at that point, didn't you start talking with the commission staff a little bit more about, hey, what wells need to be on the agreement and what wells don't need to be on the agreement? Right.
So, I mean, as operators do, and how things used to be, when these leases were, and I guess initially drilled out. So you have some wells that were drilled during certain decades and others later that people inherit well files. We inherited the well files, I think. I didn't recall the name of the operator transfer in that sheet you showed us, but my understanding was Bach is who NOG inherited those wells from. So we had our well files that we were going off of. And so when staff came back and said, hey, we need to make a change to the agreement, we're increasing the number of wells to 70 some odd wells that at least I did not even know that we had. And so from that point forward, it became we went out there several times, walking the lease with staff, trying to identify these things. So it took several months to get together on that and get this, get a list. And what I was trying to explain to them is, we had through operations, we had well signs out there, which you'll see in some of these pictures, it'll say 26B or 2WB or whatever. We had well signs, which is what we call them. And what is on the actual tags in our files, those are the names of the wells that we call them. And then, for the same well, the KCC has a different number for it. And some of these well files that we have, historical well files, a lot of them don't have API numbers. So there was several months of discussion of, hey, which wells are these? What do you call them? What do we call them? And how do we reconcile that so that we know, we're all comparing apples to apples. So it took several months to get to that point to where we ultimately signed the other agreement in, I guess, May or June of 2020.
Sure. I'm going to backtrack a little bit to the original 49 wells that were on the list. You did review each of those wells and sign off on them, correct?
I'm sure that I did. I don't recall going through and looking at everything, but
I have this email marked as exhibit KCC Cross 4, and on Thursday, October 17th of 2019, it says, John, we just checked the list to our files and it is accurate. Please send the final agreement for execution. Regards, Brent Ivy, Nacogdoches. Did I read that correctly?
Yes, you did. So I did.
Now I get, as we've kind of discussed, the well names number or the well numbers kind of changed, going back and forth. And it sounds like there's quite a bit of discussion that went back and forth between staff and Nacogdoches before reaching that final well number of 60 wells to put on the agreement, correct?
Yes, sir.
Okay. And I think before there were 60 wells, there was more wells than that. I think you mentioned something in the 70s. I'm going to pull up what I've marked as an exhibit, KCC Cross 6. And it says it's dated May 6, 2020. Russell and John, attached are my comments and questions to the list of wells contained in the compliance agreement. With respect to the KCC's API number references, I dropped the prefix 15-099 because all the well numbers begin with it. For ease of reference, I've included every single well on the KCC's list. If there's a comment of okay under the well name, then that means that Nacogdoches has no comment and has a matching well name. I've highlighted all of the wells for which we need to have further discussion or get confirmation that the KCC is willing to work with us regarding locating the well because we do not have any record of it. Please review and let's discuss what we need to do regarding the names, locations of some of these wells. I look forward to talking with you. Regards, Brent Ivy. Did I read that correctly?
Yes, sir.
And then just kind of give a sample of what we're looking at. You have a list of the wells, and if you had questions, it looks like you highlighted the well, and if it was okay, it was just left unhighlighted. Is that correct?
Yeah, the okay was to tell them, hey, I've got a well file.
Okay. And I know that later on in time, Nacogdoches submitted old plugging records for 3 wells. I believe it was it John Ord 18B, John Ord 23B, and the Spradling 48. Is that correct?
That sounds right. So you're
remember.
talking about the old historical one. I know one was the 18B because I know that there was a lot of discussion over that
Yeah.
well.
And I may have misstated. I think I said John Ord. I think it's just Ord 18B, Ord 23B, and Spradling 48. But would that be correct?
Like I said, I know 18B. I'm not trying to be difficult, but
Oh, no, you're
I know
fine.
that we submitted 3 historical numbers, in December of 2021 for some old wells that we had actually found stuffed in other well files. And, they didn't have their own well file number, but they were mixed in with other stuff, boxes we had from Bach.
Sure. And just looking at your notes for the Ord 18B, it says okay. Correct?
It does.
It doesn't mention any old plugging records or anything like that.
Yeah, we didn't have that at that time.
Okay. And the same would be for wherever they're at, the Spradling 48 and the Ord 23B, correct?
If those are the ones that we submitted historicals for, I'll agree with you. I
Okay.
don't know them off the top of my head.
There's a Spradling 48. I was having trouble tracking them down a little bit. I think the Ord 23B, yeah, it's right there.
Yes, we
Okay.
had files for those wells. That's what that okay meant is we had a file for that well. We had a file for that well.
Okay. Now, at this point in time, Nacogdoches is required to have 27 wells in compliance, correct?
I do not know. You're talking about today, as we sit here today.
Yes.
I'd have to count it up. We haven't received any kind of report or anything from the KCC in a very long time. So I'd have to count on my fingers.
Okay. Well, and I think you have it in your testimony. I'm looking at page 8, lines 14 through 16 of your testimony. I don't know that I have it. It was perfect and ready to go to share. But do you have that in front of you?
Yes, page 8. This would have brought 27 total wells into compliance under the compliance agreement in addition to the wells that were plugged.
And it continues on to say that 27 happens to be the exact number of wells required to be brought into compliance at the end of the current calendar quarter under the compliance agreement. Is that correct?
Right. So I guess technically we'd be at 30 right now because we're in the next quarter since this testimony was filed, right?
Well, I think it'd be 30 at the end of the year. So,
Right.
but I think for what would currently be due would be 27 wells. But my question is, Nacogdoches has not brought 27 wells into compliance, correct?
No, sir.
I believe that covers all my questions. Thank you.
Thank you, Mr. Marsh. Before we move to commissioner questions, let me just do a little cleanup here. You had a number of cross exhibits. Did you intend to request admission of those exhibits, or were they simply used as demonstrative exhibits for purposes of questioning the witness?
I was mainly using them for demonstrative purposes, I guess, some of them are public records, so those are more available. I guess for the emails, I'd ask that those be admitted into the record so the commissioners would have them for review if they wish to have them.
Can you identify exactly which, I believe they're pre-marked, if you could identify which items you want admitted?
I think the items that I'd like to have admitted are exhibit KCC Cross 2, exhibit KCC Cross 3, exhibit KCC Cross 4, and exhibit KCC Cross 6.
Any objection? Mr.
John, you're
Schlatter,
muted.
you're on mute.
Just to be clear, these are all emails that predate the compliance agreement. If I'm looking at this right, negotiation of the compliance agreement or something along those lines.
Yeah, I believe that's correct. The compliance agreement was signed May 28th, and I think all the emails predate that.
We don't have any objection.
Okay. The referenced exhibits will be admitted. And Mr. Schlatter, I wanted to make sure I gave you the same opportunity. I believe you referenced a number of exhibits in your cross, and same question. Would you like to request any of those be admitted onto the record or simply used for examination?
I actually have a note to make that very request to you. If we want to clean that up right now, I've got the list right in front of me here.
Go ahead.
Okay, so I had used in cross-examination, and these exhibits, save one, were previously circulated to the presiding officer, so he has them as I've marked them. They're saved as an electronic file this way, but that would be N18, N19, N19.3 being staff's responses to question 3, N19.4A, and N19.4B, and N19.7. And then in my recross, I used, and I can send these on to the presiding officer afterwards. I'll mark it as N20, but it was staff's response to my document requests, pages 4 through 32, and I'll get those over to Mr. Myers before the end of the day.
Mr. Marsh, does staff have any objection to those documents being
No
admitted as
objection.
part of the record?
Oh, I'm sorry, Commissioner French. No objection.
They will be admitted, and thank you to both of you for having most of them pre-marked and being ready to go to identify them. Appreciate it. All right, at this point, we will move on to commissioner questions for this witness, and I will start again with Chair Keen.
Thank you, Commissioner French. Good afternoon, Mr. Ivy.
Good afternoon.
I'm looking at your pre-filed direct and rebuttal testimony. I'm looking at your background. Here's that you have a BA in business from Texas A&M in 06.
Yes.
Juris Doctor from Baylor Law in 09. You've been with NOG since 2014. 2014, if I'm reading that correctly.
Yes, sir.
And you served in several capacities there. You've been general counsel. Share with me the other capacities in which you serve NOG.
General counsel and vice president of operations, which I am for the Finley family that owns NOG. They have commercial real estate, mining, helium production, other oil and gas projects, multiple investments that I'm kind of operations on those, mainly because I review contracts on everything that we do. And so I kind of have a hand in all the projects.
Okay. This just leads to my next line of questioning. To tell me a bit about NOG LLC. So it's wholly owned by the Finley family, is that correct?
Yes, sir. I believe it's wholly owned by Michael Finley.
Okay. How many different states does NOG, in how many different states does NOG operate oil and gas leases?
LLC, just Kansas.
Affiliated entities?
Texas, or we did operate in Texas. We don't really operate in Texas anymore, oil and gas operations. Used to operate a lot of wells in New Mexico, Arizona, Utah. We don't operate in sold operations in Texas, New Mexico, Utah, and still have we're a non-controlling interest in some helium stuff in Utah still.
Okay. This is a single member LLC then, if I'm understanding.
NOG LLC, the one in Kansas, yes, sir. That company does not operate in any of those other states.
I got it. Does NOG own or operate any leases in Kansas other than those in Labette County?
No, sir.
Do you operate in any of these other states, any other enhanced oil recovery projects?
In the past, we did, but we do not. We are not the, I guess you would call the chief operator in several of those areas. At one time, we were. We started selling assets 2017, 2018, getting to more of non-controlling interest where we weren't the operator, kind of downsizing and some stuff. This is the only project that we still hold where we are the quote unquote operator as far as, making operational decisions on stuff.
Okay. And in the other instances, you are an owner, but not necessarily a manager. Is that what you're saying?
Correct. I think it's the same in Kansas as it is in Texas and other states, but you have operator interest and you have working interest where you share in the profits and losses. In those leases, NOG just shares in the profits and losses. And this one, I say NOG affiliated entities or operator entities. In Kansas, NOG LLC is the operator. It only operates. It does not own those leases. The lease interest is owned by another entity that is wholly owned by Mike Finley.
Okay. And what's the name of that entity?
Dog Day Incorporated.
Okay. And I believe I'd read somewhere here that entity is a 100% owner. Is it not?
Of the leases?
Of the, no. Oh, of the leases. Okay. Tell me about that. Is that correct?
So the beneficial interest, the what we call the working interest, where you share in the profits and losses of expenses of and income of a lease. Mike Finley, the Finley family, his whole interest is owned in Dog Day, which there were multiple working interest owners up until 2019. He bought all but one of them out. And I believe right now he owns 97, or he through Dog Day owns 97% of the West lease, and I think 97% of the East lease. I don't recall exactly off the top of my head, but he owns a vast majority controlling interest in those.
Okay, let's talk about the wells here. I think Mr. Slider said we could defer to you, so Mr. Avi, that's what I want to do is defer to you about information about the wells in Labette County. We're going to focus on Kansas now. We're not going to worry too much about the rest of Mr. Finley's holdings. What are the age of these wells on these leases in Labette County? What's the oldest of these wells?
I don't know what the oldest one is because Alan Dunning showed me some wells when we were doing this, when we went out and walked the lease for the compliance agreement, some stuff that did not look like anything that had been done in the last century. That he said, you know, were on the complaint. We didn't have well files for them, but he indicated that they may be as old as the, you know, 30s, 40s, something like that. And I do know from these historical, you know, from our well files that there are lots of wells in there from the 50s. The majority of wells that that I understand, because NOG's been out there longer than I've been with NOG, is that when NOG was producing the leases in the 90s and 2000s, they were focusing more on wells that were drilled later by Bach, like in the 80s. And so like most of these wells, I won't say all, and because I don't know off the top of my head, but most of these wells that are at issue here that have either gone in out of compliance, depending on who you're talking to, most of those are wells that were drilled later, like they're Bach wells.
Say again.
Bach Corporation drilled a lot of wells in the mid 80s out there.
Okay.
And those are the wells that we have been bringing into compliance that are at issue here, and the wells that are in our development plan for when we move forward are wells that were drilled like from the 80s until later. So
Okay. Are all of these wells alternate to completions?
I'm
Do
not.
you know what I mean by that?
I do not know. I know what you meant by slim holes when you asked earlier, but that had kind of scratched out. I don't know what you mean by that.
Well, in a nutshell, an alternate to completion is a well where the casing is cemented from the bottom to the surface. Totally. It's totally encased in cement from the top of the well to the bottom. The casing. Is that the case with these wells under this compliance agreement?
I can tell you that a lot of the well files that we have that have diagrams in them do have cement outside the casing going up. I can't say that for all of them. I can't answer for all of them, but I do know that a lot of them have that.
Are they slim holes?
There are slim holes. I know of at least a handful, 2 or 3 that are slim holes.
What's the size of the casing on the wells that aren't slim holes?
I think it's 4. I think they're 4.5-inch casing on the regular sized wells.
Okay. Who does your regulatory compliance work? In Kansas.
Sorry, in Kansas,
who does your regulatory compliance work?
we have a lady in our office. Her name is Mary Carpenter, who usually does that for us.
Okay. You have an office in Labette County or in Nacogdoches?
It's in Nacogdoches.
Okay. And what about your field personnel? How many field personnel do you have?
Locally in Kansas, we use his name is Lou Foreman. He's got I know he has his own operations, but he's got a crew or a couple of crews that have been taking care of those leases for us since I think maybe 2014. He takes care of that. And then, like I said, we used to have engineers and stuff in house, but we have one guy, his name's Bill Dyer, Guillermo Dyer, but Bill for short, who is kind of he's our production guru as far as in-house for Nacogdoches Oil and Gas. So when we operate all these leases out of state, he's the one who's going around, you know, checking with all of the, you know, the ground crews and stuff on what's going on with the leases and stuff.
It looks like we may have lost Chair Keen right there at the end of your answer. Let's maybe take a short recess. Why don't we take a 5-minute break? Everybody could use the restroom if they need to, and hopefully that gives Chair Keen a moment to get reconnected. We will return it at 2:25. We are off the record.
Can you hear me? Can you hear me, Michelle, on the Zoom?
No, I can't hear you on the Zoom. I just hear you on the phone call, but
We can hear you, Chair Keen.
Thank you.
Yep.
All right, we are back on the record at 2:25, where we left off. Chair Keen was questioning the witness. Chair Keen, go ahead and continue. Looks like we've
I'm
got you
back.
back now.
Well, I'm back on it, and I appreciate the indulgence of all parties, especially Mr. Ivy, whom I don't see back on. Yes, you are. Yes, see you now. Okay, very good. I'm in a very rural part of Northeast Pennsylvania, so it happened. Let me continue on with my questioning if I can. Let me ask you some questions analogous to those that I was asking of Mr. Dooling. When I'm trying to come to kind of a well count on where we are right now. As I understood Mr. Dooling's testimony with respect to the timeline that's provided for in the compliance agreement. NOG was 14 wells behind the timeline on the compliance agreement as of 9/30/22. They were 11 wells behind as of June 30, 2022. Do you concur with this conclusion in that respect?
Mr. Keen, Chairman Keen, I'm sorry. I've been staring at the screen wondering when everybody's going to start talking. I forgot to put my earpiece back in. So about the last 30 seconds, I haven't heard you.
That's no problem. After what I've done to you and cutting all of you off, that's
My turn for technical difficulties.
Yeah, I guess it is. Let me re-ask the question if I might. I'm trying to reconcile the well count on where we are in terms of the number of wells NOG may be behind with respect to the compliance agreement. So my question is this. I'm trying to reference this back to the testimony of Mr. Dooling. It was his statement that as of June 30, 2022, the end of the second quarter of this year, NOG was 11 wells behind under the compliance agreement, and that number was up to 14 wells as of 9/30/2022. Do you concur with that?
I'll make it easy. We have not brought a well in compliance in 2022. So first quarter would be 3, second quarter would be 6, third quarter would be 9 through September 30th. So I know that we're that far behind. I think everything else is disputed today.
Okay, that's fine. That's responsive to my question. I'm not trying to cut you off, but I'm not asking you to go beyond the boundaries of the question either. So basically, I presume it isn't a dispute that the date of the compliance agreement's approval was June 11th, 2020, thereabouts.
Yes, sir.
That the date of the operator's license suspension was July 21st, 2021, thereabout. So I guess I'd ask you a question identical to that I asked of Mr. Dooling, only I need it from your perspective. Well, let me step back one place before that. Were you intimately involved in the negotiating processes leading up to the execution of the compliance agreement?
Yes, sir.
And I presume all of these processes were undertaken at arm's length, were they not?
Yes, sir.
Right. And of course, you as an attorney, were you serving as general counsel in that capacity in the negotiating of the compliance agreement, or as the chief operating officer?
Well, I had assistance with Bill Dyer on the technical stuff, but as far as reviewing it from a legal perspective, I mean, at that point in time, I was serving as general counsel on that day.
Okay. So under the terms of the compliance agreement that NOG has executed, does the suspension of the operator's license suspend the operator's compliance commitments under the compliance agreement?
It does not appear that it does from what I've heard today.
Okay. I'm going to give you as wide a latitude as I possibly can in fairness to you. Why is it that you fell behind? What are the primary, I mean, I've read your testimony, you referenced the pandemic, but why is it that you fell behind on your plugging responsibilities in Kansas?
Well, we didn't believe this agreement was a plugging responsibility agreement. The plan was to
I'm sorry.
always go in.
Let me rephrase that. That's a fair comment. Pardon my interruption too. Yeah, in terms of satisfying the terms of the compliance agreement, in terms of even having wells capable of being producing, being returned to the point where they could be actively produced, or plugging them.
Yes, sir.
Why was it that you chose the course of action you did?
It's kind of funny that you said it as far as plugging responsibility, because when our license got suspended initially in July of 2021, from that point forward, by staff, we were led to believe that all we could do was plug wells moving forward. We didn't want to plug wells because at that point in time, we were still working with our engineers to figure out which wells we're going to use for this development plan. So we didn't want to plug one that we may end up needing later. So we evaluated wells that we knew were outside the zone, the area of where our engineer was focusing. And we had priorities on stuff like slim holes and things like that. And those wells I told you about that looked like they were drilled in, the first part of the 1900s, that we were going to get to plug because we knew that we wouldn't use those wells. This plan that we're doing, those 29 wells, that's for the upper and lower Bartlesville. So once we got that going, we were going to start looking at the other wells, because there's 60 some odd wells to do, and see, well, hey, can we produce the Dennis or the Cattleman with those so we don't have to plug them, or do we just continue using those wells and we end up plugging those out? So it was kind of a fluid plan of ours. I will say, as for you asked why we got behind, I don't think we were behind, at least not until March 2nd, 2022. You said you've read my testimony, you've read my emails, us continually saying, hey, why is our license still showing that it's suspended? We're doing these things, we're doing what you asked. The first instance of that was in second quarter of 2021, when we got that notice of suspension letter, and they said that it was because there was one well that did not meet compliance. And in talking with Wichita staff and talking with Alan Dunning, I can't remember the name of the well off the top of my head, but they said it was because it didn't have a permanent power source to it. So we were pumping it with or running it with a gas powered generator, and they told us that did not meet compliance. And so we got into a discussion, or an argument rather, on, well, where does it say that I can't do that I can't use a gas powered generator? We even went so far as to take a video of the well going up and down and sending that in, and got no response on, hey, we're good or whatever, till our next quarterly report came out. And, you can see, in talking with John and talking with Alan, things appeared to be going okay, as far as they said, hey, you just need to plug these wells and everything's going to be okay. We can only go off the documents that we get. We receive these quarterly reports. Hey, it's a reminder, you need to plug or, bring 3 more wells into compliance. Hey, here's what your numbers are. And you can see in the emails that anytime there was a shortage, I immediately said, hey, what's the shortage? What's the reason? Let's talk about this. Please explain to me what's going on. So, I did not think that we were actually out of compliance up until 2022, till we tried to renew our license and it was revoked. Chairman King, you're on mute.
Thank you. For my last line of questioning, John, if you could bring up Ryan Dooling's rebuttal testimony of September 23rd.
One moment.
All right, that's it. Before we turn to a specific page. All right. And Mr. Ivy, I think, well, let's go ahead. Turn to page 3, John. Let's take a look at lines 13 through 16. And Mr. Ivy, why I'm using this as a reference point is to give you the opportunity to respond to parts of this rebuttal testimony. Line 13 says, in his testimony, Mr. Ivy states the operator has to move motors around the lease from well to well. Without motors and permanent power source, these wells cannot fall under this exception because they're not fully equipped for production or injection, and they are not capable of immediately resuming production. Have I accurately read that, Mr. Ivy?
Yes, sir.
So if I understand your most immediate testimony, what you're saying is that you were using gas generators. Were you moving this generator? Were there more than one generator?
We had a couple of different ones. The way that we produced the lease, I mean, and if you'll allow me some leeway to explain this rather than just directly saying yes
Sure.
or no, is,
Yes.
you know, from NOG's perspective during all this, we are working on a development plan from about the same time we started talking about the compliance agreement up until today. We've been working on a development, hiring engineers, you know, refining things with them, meeting contractors, doing things of that nature to get ready to implement this development plan. At the same time, we're also tasked with remaining under this compliance agreement, which is to plug or produce wells, you know, 3 per quarter. The development plan, the implementation we're going to do is very different from what we've been doing to remain in compliance as far as running wells. You know, over the last couple of years, until, you know, until before our license was suspended, oil was in the dumps. It was negative. We were trying to stay in compliance with the agreement by producing the wells within the period they had to every 90 days or so. And we used, instead of running all new overhead lines to all these wells, we moved generators around to run some of these wells because of the economics of it. All the new lines that are going to go in under our development plan are going to be subterranean. So, you know, we're trying to stay in compliance, but also further our production, our overall goal of getting these leases to where they're producing a lot of oil. And at some point you have to make a decision. Hey, are we going to run new overhead lines and all this stuff just to stay in compliance with this agreement? Or are we going to do what we can to stay in the letter of the law in compliance with this agreement until we were able to put in our development plan? And that's the decision that we made.
All right, I appreciate that explanation. I'm looking. Turn, if you would, John, to page 7. Mr. Ivy, my question would pertain to this in response to Mr. Dooling's rebuttal testimony. I'm looking here at lines 13 through 15. And it states, instead, operator attempted to use plugging reports from the 50s as a way to meet its objectives, wanted credit for wells that it did not take any action on, and did not sell oil for several years after the wells were supposedly returned to service. I'd appreciate your response to that.
Well, in candidness and fairness to Mr. Dooling, I mean, he said himself, he didn't really get involved into dealing with us until March of this year. And, with John and Alan retired, there's a huge disconnect. And I think that's where a lot of miscommunication came from. Alan and I talked a lot. Before Alan, when Russell Hine was out there, we talked a lot. Pick up the phone, call them, cell phone, text. We talked to KCC staff a lot. It seemed like we were, and a lot of the things Mr. Dooling said, he didn't have the benefit of my conversations with Alan and my conversations with John. As an attorney, I've tried to keep a good record on doing a lot of this stuff by email so that, you can see what's going on in a timeline of events, but we did have conversations. After we entered into the compliance agreement, I talked to Alan and said, hey, I found these 3 old plugging well reports, for wells that are here on this compliance agreement. Like, what's the deal there? Because if you remember me talking to Mr. Marsh earlier about how there was an initial compliance agreement that had 49 wells on it, and then it was revised to have 76 or 77 wells. Now, wells total. Injection wells, I don't think they're not counted for in the wells on this compliance agreement, because we need the injection wells to operate the other wells that are in production. So in trying to figure out and match up those well files to the KCC had gone out and taken photos of these 77 spots, and just they gave us a Google Earth representation that had SPR, I guess, for Spradling 1 through 77 or 76. And so that's what we were trying to match our well files to, from something that's 1,000 foot up in the air. Because if you look into, like, an example is in the development plan that we have, where it shows the wells that were, there's a color coded thing for the wells that we're going to utilize for injection and production wells in this plan, is it's on a map that is pin dots on the course of map, and there's handwritten numbers by the wells. I mean, that's our well map for this place. That's what we have. And so there was a lot of work with us and staff to try to refine that list and get to where we were going with that. Because what we wanted to do is create a layover on Google Earth of, these wells that the KCC had, and put them over what we have, based from our files, to kind of give a numbering system, if you will, because a lot of our well files don't have API numbers, or the name of the well is different than what the KCC calls it. There's some examples in some of the reports that Mr. Dooling has submitted here, but it was a constant thing that we were trying to work together. But we worked a lot together with that, me and Alan, Russell, John, on that. And it seemed like as they got closer to retirement, communication kind of broke down. And I know that I had a point where I was going with that, but
That's all right.
I'm trying to explain, like, where we thought we were from our perspective of what we were trying to do. And then what we were receiving on the other end was, hey, you're suspended. You need to do these things. And there just wasn't a lot of communications. Sorry, I'm wandering.
No, that's fine. The reason for my questions having to do with the depth of the wells. What was the average depth of the wells?
Sorry, I was taking a drink.
What's the average depth of these wells?
I think most of them, TD's around 750 feet, 760 feet, something like that is where most of them are.
Okay. The reason that I was asking this line of questioning about the age and the construction of the wells is the concern that I have about the fact that if I followed the numbers, you started with what you thought was 49, that went to 60, that went to 70, then it came back to 60 for purposes of the compliance agreement. I'm trying to be fair here in the numbering. And then I think by your testimony, we have some portion of these are going to go back into the 50s, maybe 40s, maybe 30s, maybe really old. That's very consistent with Eastern Kansas. Maybe not with this lease. I'm not trying to be unfair to this lease, but you have that, and then you have maybe wells that were more recently drilled. You add to that the fact that you don't have API numbers for everything. And you've had this lease since 97, I believe. Okay, am I right on that?
Yes, sir.
The absence of API numbers is kind of a signal. It isn't a certainty, but it's a signal that there may be a concern about the age of the well. And that has something to do with the cementing. If the cementing may have not in the 50s, wasn't going to be bottom to top. It would have been just around the area to be perforated. So if you don't have that cement sheath from bottom to top, some of the operations you're contemplating here under the plan, if it were to proceed, would be frustrated, impossible, or difficult, or create environmental hazards because of the absence of cement behind the pipe, if you follow what I'm saying.
Yes, sir.
But that was the reason for my line of questioning there, was trying to come to grips with the practicalities of working through the plan as you anticipate and want to see it play out. So with respect to it, you can answer if you wish anything I've said here.
Well, I was just going to say, is my understanding from historically from talking with Mr. Finley, who was involved early on, he's gotten up in years. He's not as involved as he used to be. Is that I don't know if it was him or if it was Bach, but somebody a long time ago actually did attempt a water flood out there and it didn't work. And maybe for those reasons is that they weren't checking things out to see where stuff was perforated and stuff like that. So we do have some knowledge about that. Hey, this was tried again, and we're, part of what we're going to do is correct that because, do it the right way this time, really. I mean, and that's why we hired the guys that we did to do what they've been doing.
I appreciate that answer. And that was barring any next question, which was the degree of experience that your operating field hands have with operating either water flooding or polymer flooding operations. And because of the complexity of it, do they have experience in doing that sort of thing?
Our engineer, Aon Consulting, his name is, I literally just read an email from him over the break because I was trying to figure out when we hired him. And as things often happen, Jim Weaver from Aon Petroleum Consultants is the engineer that we've retained to do the development plan. He has experience with that. And I mean, part of what we were doing in the fall, winter of last year, we're interviewing contractors who did have experience, trying to find somebody with experience because doing what had been done in the past with a guy like Lou Foreman to go out and pump these wells who were in their tertiary stage of production was not going to work. I mean, our development plan is a revamp from top to bottom on, utilizing people in the field, the equipment. We're not going to use, aside from using well bores, which a lot of the well bores that we're going to use are either going to be, we're going to convert some of those from injectors, producers, and vice versa. So we're trying to basically, no old flow lines, none of that stuff will be done. So it's kind of a fresh start. So yes, the answer to your question is yes, who we hire will certainly have experience in that. And our engineer is going to be over those guys.
At the time you entered into the compliance agreement, was it your intention in entering into the compliance agreement to basically buy time to plug out the lease? Was that the intent originally?
Well, by time, yes, because I think we had approached on a lot of these wells the 10-year TA limit. And it
Okay.
was, our understanding when meeting with staff is that was the only way to go was to enter in this compliance agreement, where we could start plugging and producing some of these wells. And we started out by doing stuff that was close to where our power was. What's easy to get to? What time of year is it? That's how we started. And as we started going into that, we started getting, okay, well, let's plug some of these wells that we need to do. A lot of the wells that some of the wells that we wanted to plug are way back in the back that Mike Wimsett couldn't even get to when we plugged those ones in September of the year. And we had, you have considerations with the farmer and crops and all that kind of stuff. So the answer is yes. We were trying to buy some time because we knew that we were going to implement a development plan, didn't know what kind. And if this bought us time to be able to do that, that's what we were going to do. By NOG's past operating history and production of oil is, I mean, it had backed itself into a corner to where it had to enter into a compliance agreement. And so we were trying to buy time to where we could get to where we could spend money out there.
Mr. Ivy, I appreciate your candor. I appreciate your responsiveness to my questions as well. That concludes all of my questions. Thank you.
Thanks, sir.
Thank you, Chair Keen. Commissioner Duffy, do you have any questions for Mr. Ivy?
I do, and thank you. Good afternoon, Mr. Ivy.
Howdy.
So I'm looking at your testimony. I'm on page 7, the last line, line 30. You say, based on this, NOG assumed its license would be reinstated. Further, if I read elsewhere in your testimony, and I'm looking for that, you again state that you assume, it's on page 8, line 28, again, NOG had been operating under the assumption that it had met all the quarterly compliance objectives. I'm bringing this to your attention because I note that your attorney in his opening statement believes that what this case is about the lack of communication, the failure of communication by staff, I believe was his quote. You're an attorney. I've never known attorneys to assume anything. So I would like you to, if you had questions and you're representing the company, why would you assume, especially when you discussed that you had a good working relationship with John Almond and some of the other folks before they retired? So explain that to me, especially on something, a compliance agreement, a legal agreement that you signed on behalf of NOG.
Because that's what John Almond told me. John Almond told me, had said, hey, get this well back into compliance, plug these wells, everything's good. And, you know, as Ms. Bohr stated earlier, that when you log into Kohler to file a report or something like that, you see up at the top, it's in red, it says your license has been suspended. We were told that we did not have to file TAs and stuff like that, continue filing TAs for all the wells that we haven't gotten to yet and all that stuff while we were under the compliance agreement. So when I want to say from the first time that I noticed it, from July 2021, when our license was suspended until later, is when we filed the CP1s and CP4s for plugging, and it still said, hey, your license is suspended up here. And so you call and say, hey, John, what's going on? Why is it saying this? We got that well, the one well that you were asking about in July, we put that in compliance. You know, my guy was out here, you know, turning these wells on, you know, what's the deal here? Well, hey, just plug these 3 wells and don't worry about that. You just keep doing what you're doing. Everything's going to be fine. So, and that's why I get into it. We had a good relationship with these guys. Yes, I'm an attorney, but I work for an oil and gas company. There's a lot of stuff that's informal that's done. Sending out demand letters and things like that is not a good way to make friends. When you can do something informally and you have a good relationship with people, that's what you do. And that's what we thought we were doing with these guys. And I say these guys, I'm talking John and Alan before they retired. I really do think that everybody knows if you've left a job before, you know you're leaving a job before it's not as big a priority when you get to them. I'm not saying that happened with John or Alan or anything, but when they transitioned and, you know, we're dealing with Ryan now, you know, there's a lot's lost in translation, a lot of miscommunication. That's why I tried to keep good records of emails in this case.
Okay, so you're active in almost 6 other states. I mean, Utah, Texas, Oklahoma, New Mexico. So I'm assuming you deal with their regulatory agencies, correct?
Well, I did when we operated in those states, and some of those, the New Mexico assets, the Texas assets, those were gone before I came on board. I was just giving that more of a historical reference. I dealt with the BIA and the Bureau of Indian Affairs in Arizona and Utah because those were on Navajo leases. So we dealt with a lot of different governmental agencies.
So other layers of regulatory entities
Yes, ma'am.
beyond just the state.
Yes, ma'am.
So would it be safe to say that you're familiar with the regulatory landscapes? Maybe not specifically, but understanding how the oil and gas activity in every state is regulated, that it is, and my emphasis on is regulated.
Yes, ma'am.
Okay. Do you have compliance agreements, and did you at that time have compliance agreements in other states?
No, ma'am.
Okay. All right. So when I'm on page 13 of your testimony on line 4, NOG suggests that the final compliance date be extended 1 year until July 30th, 2026 to allow time. So regardless of the practicalities that Chair Keen was referencing, when did you first share this idea of extending the agreement 1 year? Since this had been a process, thought process, and then hiring a firm to actually do the study, when did you first suggest that this extension be granted? When did you first reach out to staff with this suggestion?
I didn't reach out. I mean, March 2022, when our license got revoked, and we didn't get a meeting with Troy and Ryan to talk about that. We hired John Schlaughter. We've been dealing with counsel through that. We've actually tried to, you guys, I don't know if you guys know, but when this thing was originally filed, we tried to mediate and go talk to them about, hey, can we make a deal here? And they refused. So, but I mean, I'm probably told John that day one is, hey, we haven't been able to do anything for all these, 6 months now. I mean, hopefully we're going to get a tolling period or credit on that, because that's not fair.
I don't know Mr. Schlaughter. So, so you retained him, and I'm assuming he resides in Kansas and is an attorney for in the state of Kansas,
Yes, ma'am.
and that he's familiar with oil and gas law.
Yes, ma'am.
Okay, so when you retained him, which was at the beginning of the year, did you say? Or in March?
In March.
In March. Did he not, I'm sorry, I have a gnat flying around here. It's been bothering me all day. Did he not share with you his expertise in this area in terms of what compliance agreements was he familiar with them?
Yeah, I mean, we had lots of discussions about the compliance agreements, where we were, that sort of thing.
Okay. So let me look here. One other question. When you first received the notification that your license was not renewed because you were out of compliance, please share with me again, what was your first action after learning of this? What was your first action with the commission? Did you call? Did you write? What did you do, and what was the date?
I want to say it's in my testimony, my pre-filed. I don't want to, whatever that says, it is right because I have the ability of looking at emails and things like that. But I want to say the first thing I did was call the number that was on the letter. I want to say that.
Okay,
Or maybe I called, I may have called Russell first because anytime I've ever had an issue, I call Russell Hahn to say, "Hey, man, what's going on here? I'm not. This is unfamiliar territory." But it would have either been to call that number or to, reach out to staff. I don't know which one I did first.
okay. Also, I do believe Chair Keen brought up the fact that the NOG has owned this lease since 1997. And while it appears much of your testimony was confusion about which well was which, whose responsibility is it to nail down the well to a piece of paper, to a number, to an API number, whatever, and find agreement with the regulatory responsibility? Do you believe that is your responsibility as the operator? Or do you believe that is the responsibility of the regulatory agency? And please tell me why, if you do believe that.
I would say absent this particular compliance agreement, it would be the responsibility of the operator. But as you had questioned Mr. Dooling about negotiations and the compliance agreement, you heard me talk about how there were this many wells and that many wells and our files don't match theirs throughout that whole process. Because when we ended up signing that agreement with 77 wells on it, I was scared to death because I was like, what happens if we can't find one of these wells? I'm taking your word for it that they're there because we don't even have this many well files, ma'am. And that was the understanding that John and I had going through there is, hey, we'll work it out together. We'll figure it out together. That's part of what they were supposed to get me the geographic overlay that I asked for numerous times so that we could match that system and start working together. So that's my answer to that question.
Okay, thank you. Thank you, Commissioner French.
Thank you. I don't believe I have any questions. Mr. Schlatter, do you have any redirect?
We can go down the NOG attempted to resolve this with staff ahead of the hearing if you'd like. There's email correspondence to that effect. If that's not something the commission wants to hear about, we don't need to do that.
Well, I'd like to keep us on pace for wrapping up fairly soon. I would give you a short leash if you think there are a couple very relevant questions that are going to stick pretty close to things that have already been asked. But I'll let you use your discretion, just knowing that if it goes on and seems wide ranging, I may cut you off.
I would, yeah, I hope you do. This won't take very long. Thank you, Commissioner French. Mr. Ivy, Commissioner Duffy had asked whether NOG attempted to resolve this with staff, basically enter into a new agreement. Do you recall in about March of this year, March 21st to be exact, being copied on an email correspondence seeking that exact type of amendment from commission staff?
I know that there was one. I don't know the date of it.
That's okay. Was March sound about right?
Sure.
Yeah. Do you recall staff's response to that?
I don't think there was one.
Why don't we, if I may, just publish this email correspondence real quick because I had forgotten about this. Can everybody see that?
No,
Could you zoom in a little, please?
Okay. So this is an email dated March 21st from myself to Mr. Marsh, copied to Mr. Ivy, basically saying I've been retained. Brent, why don't you read that over and just provide your comments on it rather than have me read an email to the group?
Okay.
Just refresh your recollection.
Okay, I'm through it.
Okay, so you recall this email?
Yes, sir.
You just briefly testify as to its contents.
It's essentially an email from you to Mr. Marsh saying, hey, NOG's retained me because of this license suspension or non-renewal. There were some disagreements that arose. You talk about that we've done an engineering study and would like to institute a water flood, and we'd like to discuss amending the compliance agreement to allow it to conduct a water flood to prevent waste and protect correlative. Obviously, our license would need to be reinstated and that the compliance agreement modified. Would it be possible to schedule a meeting with staff to discuss this in the coming weeks?
Okay. And then I'm going to go up, skip that email. Now we're at April 22nd. We want to just review that and summarize the response.
Okay, so it's about a month later. Mr. Marsh says, John, sorry for taking a while to get back to you. Staff has not expressed any desire to meet with NOG at this point. My understanding is that NOG has brought 13 wells into compliance with the terms of the agreement. Unfortunately, they were required to have 21 wells by the end of the first quarter 2022. Additionally, I've been told that since NOG is behind, staff would not support the amendment of the agreement. As far as their license goes, they'll be issuing an order denying application for license, most likely within the next week or two. If the order becomes final, staff will look into pursuing a penalty for unplugged wells on an unexpired license.
Okay. Then it appears we had some kind of a pre-hearing conference after that related to this matter. Again, there's an email dated June 24 where we reach out to staff again about possible settlement. You want to just summarize that email?
So this is 2 months later from the previous email. And you told Mr. Marsh that, hey, it sounds like the presiding officer's encouraging us to get together and work a resolution on this matter and the compliance agreement during the hearing yesterday. Do you anticipate staff changing its position regarding the discussion in that regard? Please let me know. NOG remains willing to have that discussion. Just name the time and place.
And then I believe this is the last email. It's a few days later.
Yeah, a few days later in June, Mr. Marsh didn't anticipate staff changing their position on the license denial as long as NOG's license is suspended for non-compliance with the commission-approved compliance agreement. As far as the compliance agreement goes, my understanding is any discussion that would cause the final deadline to be later than the current deadline is going to be a non-starter. If NOG is looking to have all the wells returned to compliance in that time frame, I can check to see if my client is willing to have more of a discussion.
Okay, that's it. That's the end of it. And then I believe here's where we are, correct?
Yes, sir.
Okay. That's all I had on that topic.
Mr. Slider, would you like to mark that email correspondence and have it entered into the record?
I can do that. I'll send that with the other exhibit I mentioned earlier today. If there's, I'll offer it if it's admitted.
Yeah. Why don't you offer it and then we'll see what staff has to say.
I would like to offer that email chain trailing from June 29 to March 21 this year.
Mr. Marsh, does staff have any objection?
No objection.
It will be admitted.
And that's all I have for this witness.
Okay. Let's
Mr.
what I'm gonna do.
Commissioner French, if I might ask 2 follow-up questions.
Sure.
Begging the indulgence of everybody involved. 2 follow-up questions for you, Mr. Ivy. Prior to the license suspension, what was the productivity of this lease? What was either the daily or annual average production for this lease?
It had been very low. These wells produce at the, current stage of tertiary production where they'd make anywhere from a quarter barrel of oil a day up to maybe a barrel and a half a day. And like I said, we weren't, given the price of oil, we weren't pumping them every day of the month. So not a lot.
Total daily lease production would average what approximately?
Oh, from what I can remember, before I actually got involved in 2016, I guess, I want to say they averaged selling, maybe a load of from the first crash in 2014 on, they would sell a load or two a year off of these leases.
These are into 100 or 200 barrel tanks.
I think they're 200 barrel tanks, I think is what we have out there.
So the annual production would be somewhere between 200 to 300 barrels a year, right?
Yeah, because we sell a load, in a 180 barrel truck is when they came and picked it up.
That's a 200 barrel tank. The reason I'm asking that is because even if you were having the license reinstated and you have cash flow, let's say even coming back to that level of production, I'm concerned about whether that level of cash flow is going to be adequate to even conduct the kinds of operations that you're contemplating under the plan water flood. That's where I was headed on that. It appears to me that you'd have to have external funding to complement cash flow to affect the operations. Is that correct?
Yes, sir. And we do have that.
Okay. Mr. Snyder, I'm going to beg your indulgence once again. If you could bring up again that exhibit that I was asking questions of Mr. Dooling about, the one that is the one that references his retirement. If we do it enough times,
I believe
we'll
it
all
was
know.
8.
I think it was 8. Yeah.
Yeah.
Yeah, that's it. Maybe just slightly larger, John. Thank you. Mr. Ivey, my final question is this. Again, let's see if we can take the index out of the middle there. You had it, John, and now it's gone. Yes. Here's my question, Mr. Ivey. We don't need to read it out loud, but read the first sentence.
Yes, sir.
At the time you received this letter from Mr. Ullman, this email from Mr. Ullman, what was your take on the responsibilities you had as operator when you read that first sentence?
That we had to do 3 more wells by the end of the year.
And that would be notwithstanding the fact that at the time of this email, your license was suspended.
I can't say that I knew for certain at the time of sending that email whether it was suspended or not. I knew that we were in compliance, or at least we believed that we were in compliance based on what John and I had talked about. We just finished plugging 3 wells at the end of the third quarter.
But you were still subject at that time, were you not, to a suspension order, the last definitive statement by the commission on the subject matter of these leases and that compliance agreement that was dated July 21st, 2021.
I'm sorry, I mean, at this point in time, we're acting as if we're getting our licenses reinstated and we're continuing to work. Technically suspended, like I said, we didn't log into Kohler every day to see that we were. I'm going off of what our compliance guys telling us that, hey, plug these 3 wells and your license is back in statement. I hadn't looked into Kohler since that time.
Oh, so your take on this letter was that if you plugged these 3 wells, notwithstanding the arrearages you had up to this time, that your license would be reinstated. Are you saying that? No.
No, sir. No, sir. If you scroll down and look at I don't know if it's this is like an automated thing, I think, maybe. I think this might be an automated message, like that we would get one of these that has, this is a courtesy, or maybe it's just a form email that John would always send, but he would always send that at the beginning of the last, I think Mr. Dooling said about halfway through the quarter, say, hey, this is a reminder, you've got this. And that's usually when we would get that list of wells that we've done. And if you look at the one for this, I'm pretty sure it had that we were like 15 of 15 on here. If you can scroll down, it's got a PDF attachment.
This one doesn't have the PDF on it,
Okay.
but that report we went through that on earlier. If you want me to call, this isn't my witness at this point, but we can call that exhibit up.
Okay. That concludes my questions. Thank you, Commissioner French. Thank you, Mr. Ivy.
Thank you, sir.
In fairness here, I believe I offered Mr. Schlatter an opportunity for recross on staff's last witness, given extensive examination and commission examination. Mr. Marsh, I want to give you the optional opportunity for recross. I think we've wandered into some new areas. Do you have any recross?
Oh, I don't know that I have much. I guess just to be transparent and provide full context, there were additional emails in that exchange between Mr. Schlatter and I. And so I'd like to at least pull up I think there's one more. So at least share that just to provide full context. Mr. Ivy, this is an email from Mr. Schlatter to me dated June 29th, 2022, correct?
Can you
Yes,
make
sir.
it a little
Is it-
bigger, Kelsey?
Yeah. I'll work on that. Is that better?
Yes,
Maybe maybe not the date's better, but unfortunately it's not a PDF. I just was searching through my emails. So that's how I got to it. But it says Kelsey, NOG intends to implement the water flood project as soon as it possibly can, given enhanced commodity prices. NOG has already acquired a pooling unit, so it does not have to wait on vendors to get going. Sourcing materials and equipment is really the only remaining variable. In any event, there is no intention to request an extension to the June 30th, 2025 deadline date. In fact, NOG may be willing to shorten that timeline if it will assist in obtaining staff's cooperation and approval on amending the compliance agreement. I hope that's helpful, John Schlatter. Did I read that correctly?
Yes, sir.
Okay. I don't know that I have any other follow-up questions. If you want me to PDF that and attach that as exhibit, I would mark it as exhibit KCC Cross 8 and share it with John and Mr. Schlatter, and that way we have that additional email attached.
Is there any objection to that, Mr. Schlatter?
No, I think that's great.
So can I ask, what was the date on that? You took it down before when you scrolled back so I could see it. What
Sorry,
was-
the date's also June 29th, 2022.
Mr. Marsh, does that conclude your recross?
I believe so.
I think we are going to go ahead and conclude with that then. Let's see where we are. Now
I
that we've
guess,
made it. Oh, go ahead, Mr.
I'm
Marsh.
sorry to interrupt. I just didn't know if there was still any desire to have Mr. Dooling come back and see if he's found out any information from staff's perspective regarding Chair Keen, questions from earlier or not.
Let me jump in here just briefly. No, it's not necessary for him to come back. Mr. Slider, would you have any objection, or you, Mr. Marsh, if the the information which I was asking for was rather specific, I think, on 3 issues or 4 issues, I forgot which, with respect to the wells under the compliance agreement. If that was filed in a supplementary way, would you have any objection to that?
I wouldn't.
NOG, no, I mean, NOG probably has the well files. I don't know if that's, you want to go that in depth into it.
Some of them.
Chair Keen, are you requesting that the parties stipulate to a filing, or are you requesting that one or the other make the filing?
I guess I'm requesting a stipulation to a filing.
I mean, Brent, would you be able to get the well completion information assembled, or is that something I don't know if staff has that or not. And if some of them are old, it may not be in the library or anything like that. We
You would
can
hope that they'd have the same information as the well file. I mean, those well files are, they're old and big as far as just, it's going to be hard to like scan them in and send them somewhere. It would almost have to be like a physical inspection, but I mean, we can look through and see what we can.
maybe the best way is have Mr. Dooling assemble what he has, and if there's missing information, we can supplement, or NOG can.
Yeah, that sounds fair to me too. What I'm contemplating, and I may be off base here, what I'm contemplating is incidental to the lead up to the compliance agreement. There's going to be right within the file for that compliance agreement, there's going to be this kind of information about those wells that was provided by staff inspection or staff research as a lead up to the staff's submitting that for commission approval. That's what I'm hoping. It's something that simple. I'm not really looking for a whole bunch of de novo research here at all. So that's what I'm hoping exists. But I think your suggestion is fine, John. Pardon my interruption here, Commissioner French.
Let me just nail this down. For the parties, how much time do you think you'd need to work together and pull together a joint filing? Recognizing it is a holiday weekend next week.
Yeah. Sometime after this Saturday. I think if that I wasn't aware of what went into the file when these compliance agreements were made. If that's the case, then I think as soon as we get it, take a look at it, and if there's anything we need to add, we can do it. But I don't want to make any promises for Mr. Dooling, but 2 weeks, 3 weeks.
Mr. Marsh, is that acceptable? 2 weeks?
I think so. I know that staff's already been kind of compiling documents and well, maybe not documents, but at least kind of looking at the information. So I think whether we just do like a paragraph or we actually attach documents, hopefully we should be able to get something within the next couple of weeks.
Well, we're not going to issue an order on that, I don't think, but I am going to request that you file that joint filing no later than 2 weeks from today. Obviously, earlier is better. All right. Let's see where we're at. I believe we're now ready for closing statements. I don't know that there were any time limits established, but we've taken a lot of time today with examination, so I think I will ask that parties be brief. Mr. Schlatter, we'll have you go first.
Thank you, Commissioner Chair, Commissioner French. Yeah, I think we've covered a lot of ground today through testimony. I don't think this needs to be overly complicated. At least I feel like we have 2 stories going along here. We have the story that's in the evidence, which is NOG and staff's communication back and forth. We think we're compliant. In many cases, affirmative agreements of compliance or affirmative reports demonstrating compliance. And then we have this post facto pre-filed testimony, you were supposed to do this, or we went back and looked at this and decided it's not in compliance anymore. And in my opening, I mentioned equities. I don't think that's necessarily fair to armchair quarterback it like that. This agreement was signed in June of 2020. It is an agreement, it is not an order. And there were mutual obligations, as all agreements do, to do things. NOG was to follow its schedule and bring wells into compliance. It did that. It told, and staff agreed all along the way. Staff was supposed to tell it if it wasn't in compliance, and that happened a couple of times, really once before March of 2022. And that happened in July, and NOG fixed it. And the record shows that in September of 2021, 15 out of 15 wells in compliance. So one time they told us you're not in compliance, it immediately gets fixed. Next time it happens, March 2nd, 2022, you're one well short, happens to be the same day that the letter comes out saying your license isn't going to get renewed. And so at that point, NOG shut in its wells, which was what it was told to do at that time. There's a March 7 letter, it's exhibit N12. It says you shall shut in your wells and stop producing. Of course, the wells are going to fall out of compliance with 82.3.133 because they can't produce them, or at least they think they can't produce them. So I think it's unfair to continue that clock running to date when it believes it's not supposed to be, when NOG doesn't think it's supposed to keep producing. I don't believe that to be fair. I think that's inherently unfair. We have, implied covenants of good faith and fair dealing at common law in Kansas that say you can't frustrate the purpose of the agreement. And I believe that does frustrate the purpose of the agreement. Whether they should have been following that compliance agreement or the directives from the staff, it sounds like there's some confusion there. But I think what NOG really wants today is a restart on that agreement. And it's willing to commit to a restart on that agreement with a substantial investment in District 3 in Southeast Kansas, a place that needs a lot of investment. And it's willing to commit to a timetable to bring all of these wells into compliance, whether by production or by P&A or converting them to injection wells to implement a development plan that its engineers, its retained engineers, have indicated will be successful. And those are people they've paid a substantial amount of money to design this plan. If that plan fails or falls flat on its face, or NOG can't make its commitment, then it's over and we're right where we are today. If it's successful, everybody wins. I think that's a pretty good outcome in this matter, but it needs its license to do these things. I think it's something the commission can order today. It can take its previous agreement and it can amend it, it can modify it, it can replace it. It obviously has that authority. We've submitted a framework or a guidepost, deal terms, if you will, and the commission can take those as they see them and modify them and tailor them to whatever they want them to be. That's where we are at this proceeding. NOG's made some suggestions. If those aren't good enough, we'll be happy to know, you tell us how high to jump and we'll jump that high. So that's where I think we're at here. And that's what I hope is the outcome of this proceeding.
All right, thank you, Mr. Schlatter. Mr. Marsh.
Thank you. Just a few comments on Mr. Schlatter's closing. I know he talked about, saying wells were in compliance and then commission staff kind of armchair quarterbacks the thing and takes things back. I mean, that's not exactly what was the case here. It was wells that Nacogdoches just told staff were in compliance, and then staff later found out the wells had not been brought in compliance whenever they performed their lease inspections and followed up on inspecting the leases. I know Mr. Slater also said that this was an agreement. It wasn't necessarily an order, but that's also not the case because the commission issued an order approving the agreement. I believe it was on June 11th of 2020. There's also things saying the wells, there was no choice but for the wells to fall out of compliance after the shut-in order or suspension letter was sent, but that also isn't necessarily the case either, because as we heard with discussing or whenever we're visiting with Mr. Dooling or whenever he was testifying, operator still has the choice to file temporary abandonment applications or plug wells, things of that nature. They talk about how the clock still ticking is inherently unfair, but I mean, the agreement never says that the time starts to toll once a suspension letter is sent. Kind of restarting the agreement would also be kind of unfair to staff, because staff obviously put in a lot of time and effort of locating these wells and putting the agreement together in the first place. And so to kind of go back and just say, okay, well, we're just going to restart all over again. I don't know that that accomplishes what the compliance agreement was initially there to accomplish, because, you know, compliance agreements are great things, right? But it's kind of a second opportunity to say, hey, we have wells that are out of compliance. We need to get those brought in compliance in a timely manner. Here we had an agreement in place and Nacogdoches didn't meet the terms of the agreement. All that to say that, you know, really the question, as we said from the beginning, was the question before the commission is whether Nacogdoches is in compliance with all Kansas statutes annotated, commission rules and regulations, and commission orders and enforcement agreements. And, you know, just looking at it from that lens, Nacogdoches is not. You know, even Mr. Ivy himself said, hey, you know, we have not brought 27 wells into compliance with the agreement. So looking at it through that lens and the statutory guidance or mandates that are there, staff believes that the order denying license application needs to be affirmed. Thank you.
Thank you, Mr. Marsh. All right. Finished closing statements. Let me just check if there are any final post-hearing issues. It's my understanding the parties don't see a need for post-hearing briefs. Is that correct?
Correct.
All right. Not hearing anything different. Are there any other post-hearing issues? We've already cleared up the matter of the information requested by Chair Keen. Is there anything else the parties want to mention before we conclude? All right. Hearing nothing, this will conclude our hearing in this docket. This time we will close the record and adjourn. Thank you all for your participation. See you all later. We are adjourned.
Thank you, everyone. Thank you, YT.